On your side, may
I সাইড আমি শেষ হলে বলবে অ্যাপ্লেট সেট কখন তখন may I pray for leave without certified copy 25th July 2023 is the order first 25th July Lord applets
restoration application.
Lord, I am come again to bother your lordships. Lord, I had mentioned this on the last week also. Lord, with respect to the assigned matters, your lordship said, Lord, your lordship would be keeping a day, Lord, so that if there's some urgency, I have some matters in the assigned list, Lord. Lord, whenever convenient to your lordships, Lord.
We can't tell you which day, but someday next week.
I'm grateful. I'm grateful.
They will be listed immediately after the applications.
Very.
Before specially fixed or before.
Very. No, whenever my concern is the matter should be called on, Lord, so that that's my only concern.
On that day, if we find 23 applications,
that
we
is
don't know, but we'll yes.
I'm great.
My lords, may I be permitted to mention one matter for inclusion in the list, lords?
Lordship, I am praying for leave to file this appeal without certified copy, Lordship.
When was the order passed?
8/6/2023, Lordship.
8 June.
8 June, Lordship.
When did you apply for certified copy?
2nd August 2023, Lordship.
Why? Neither.
Okay.
item number 1.
Item number 1, my lord, I'm for the appellant. My lord, matter was disposed of.
Disposed of?
Yes, yes, my lord.
Please.
But
Oh, there was some
direction, my lord, the within 15th August.
dereliction of duty on the part of some officers.
I am told that 8th August, the final hearing has been concluded by the learned tribunal. My lord. Hearing has been concluded.
Sure. This is the report we had called for. You have nothing to do with this. We will look at the report later.
Yes.
We had asked the commissioner. Na?
But 15th August, my lord, lordship's direction was that.
We had asked the DG building to cause an inquiry and find out which officer is responsible. That report has come.
My lord, I am told that, my lord, matter has been, my lord, hearing has been concluded on 8th
Very
August.
good. Aki korbo order. This disposed of matter has been listed since the report we had called for from the Director General, bracketed building dash Roman 2, bracket closed, comma, Kolkata Municipal Corporation, by our order dated June 22, 2023, passed in APOT 185/2023, has been sent to the registrar, original site, and the same has been placed before us. Stop. We have taken note of the report. Stop. This matter shall go out of list. পাঠিয়ে দিও এবার দেখে নেব কি দিয়েছে
New application, item number 2.
Number 2, my lord, I'm appealing for the appellant, my lord. There was a direction to file, my lord, supply them a copy of, they will supply a copy of an report in form of an affidavit showing, my lord, the power of an executive engineer, my lord, to grant sanction, my lord, under the Kolkata Municipal Corporation Act, my lord, in respect of a construction of a building coming up on a site. My lord, what happened on a site, my lord, on a plot of land. Now, my lord, what happened here is, my lord, it was, my lord, a construction was coming up, my lord, and a stop work notice was issued, granted to you. And a demolition proceeding,
Mr. Chatterjee, just give us a beat. I at least remember nothing. Let me see my earlier orders.
কালকে সন্ধ্যাবেলা পেয়েছি হাতে। হ্যাঁ, হ্যাঁ। দেখেছি।
For the private respondents,
I am the private respondent. Lordship.
who is representing state?
I am protest.
Oh, you were to file an affidavit.
And I have, my lord, initially I have filed a report. He, my lord, has taken an exception. Then, my lord, he questioned the issue, my lord, whether the executive engineer could, my lord, issue a sanction plan.
Reconstruction plan.
Reconstruction, my lord. On that, my lord, your worship has directed us, my lord, to file a supplement, an affidavit, my lord, report in the form of affidavit. In fact, my lord, I am submitting it, but the thing is this, my lord, that cannot be issue in this present appeal. Because, my lord, what I have contended, if he has any grievance, he can raise an issue, my lord, before the other forum. Because here in this case, only he complained about the unauthorized construction. We submitted before the honorable single bench that the construction is being made in accordance with the sanction plan. Now, only here in this case, the IUD report submitted. But so far as the plans regarding the sanction of the plan is concerned, that may be an issue to him, my lord, for questioning. But that cannot be questionable here. But however, my lord, I am filing this, my lord, report. You also see, my lord, that 410, to whatever the plan was sanctioned by the executive, to that extent, my lord, he has the power. But over and above the reconstruction plan which was sanctioned for limited scope, executive engineer holds a limited scope regarding the sanction. He exercised that power. But over and above, my lord, further and other unanswered construction was there. On that issue, my lord, we initiated proceeding, demolition proceeding. In that proceeding, my lord, the unauthorized constructions were allowed to be retained. That plan is there. Therefore, he might have any grievance with regard to the order, my lord, passed by the special officer building, allowing retention. But that is not the issue here. And after the construction was completed, because it was an incomplete incomplete stage when the demolition proceeding was initiated. Then since it was allowed to be retained, then it needs to be completed. Then he submitted further reconstruction plan which was allowed. This is the position, my lord, right now.
So as of date, there is no unauthorized construction.
There is no unauthorized as such. He might have a question regarding allowing retention. What about the nature of the construction which has been allowed? He might say that it cannot be allowed by the special officer building. So far as the reconstruction plan is questioned, my lord, if he has any question on that, my lord, he can raise an issue before the applicable forum.
You are a neighbor.
But my lord, what is happening?
Are you a neighbor or not?
Yes, my lord, I am a neighbor. My lord, I am just the adjacent plot holder. My lord, what is happening? My lord, what is happening is, my lord, the neighbors to my plot, my lord, on the one plot, initially illegal construction was coming up, my lord, I complained, they shifted back.
Mr. Chatterjee, rightly or wrongly, the special officer building has allowed the private respondents to retain certain unauthorized constructions. If you have a remedy in law before any other forum, go and challenge it.
My lord, this is not the question here, my lord. May I just
What is
indicate?
the question?
Will I tell you, Lordship? Will I initially what happened, Milord? A stop work notice was issued, a demolition proceeding was initiated. Milord, in that juncture, Milord, I found, Milord, I was not part of that demolition proceeding. Milord, what I found, Milord, a 3-storied building is coming up. I made a complaint before the authority. Milord, from RTI, I obtained information that he has obtained a reconstruction plan for reconstruction of the damaged roof only. Nothing more, nothing less. Milord, under Rule 32E, Milord, I forwarded them the complaint. You have sanctioned 32E only, but how can he construct a 3-storied building there? Milord, demolition proceeding was disposed of behind my back. Milord, I was not aware this has come up by way of this report now. Now, Milord, what happened? My representation remains there. Milord, I filed a writ petition. My complaint was not entertained. Milord, the Honorable Single Judge, Milord, on the basis of a report filed by the state, where the answering respondent was Kolkata Municipal Corporation, dismissed the report, writ petition, saying that state has said there is a reconstruction
Your
plan.
representation is still pending.
Still pending. Now, my lord, what is there, my lord? Now, when I come up in appeal, my lord was pleased to direct them to call for a report. They filed 2 reports, one by the water department of the KMC and one by the, my lord, executive engineer building department. Now, building department's report says none of the plans, my lord, has been sanctioned by the sanctioning authority, but there is an approval of the executive engineer. My lord, I question the fundamental root that how can the executive engineer, my lord, approve a sanctioned plan? Milord, there, Milord, my lord, call them, Milord, to file a report, furnish a report. What is happening? How he is having the power to do this? Now, if for a moment, Milord, the special officer building is retaining some portion, which I find that is with respect to one room in a partly 2-storied portion. Milord, nothing more, nothing less. Milord, what happens? He retains that part only.
How do you know what?
Milord, he has applied it in the report. Now, Milord, what now? When the other portion remains to be demolished, he files a reconstruction plan that permit me to complete the 3-storied building. The executive engineer, Milord, as per the report filed before this court, says I have approved. Now, Milord, the report which is annexed to the affidavit also, Milord, I say the executive engineer has not even approved. Not even approved, but the report says otherwise. The report says otherwise. This is one part. Second part is under law, Milord, the circular which they have placed, Milord, showing the delegation of power, Milord, the power of sanctioning is not delegated. In my respectful humble submission, the power of sanctioning is not delegated. If for a moment, Milord, takes up the report for once, Milord, this is malafide practice going on.
One report is also from executive engineer water supply.
Yes, Milord, to that I have used
but
an
that-
exception.
I'm not going into that issue, no, because that is not the issue here, my lord, for consideration. That was, my lord, given to us. Well, I did not consider that it is relevant or not. That may not be looked into by the lordship.
Milord, but I will take my lords to that also because that report would show the malafide apparent on the face of it. And I have taken out an exception which I have supplied them a copy to. Now, Milord, kindly turns to the page 21 of the report for a moment.
The power appears to have been delegated to the executive
No,
engineer.
Milord, I shall, Milord. Kindly turns to page 24 for
You kindly come to page 9, first explain.
page
9.
9. Yes.
Power
Yes.
under section 393.
Yes, Milord, I shall. Milord, kindly sees, Milord, this is, Milord, a municipal circular 173. Milord, it says, Milord, the what powers are delegated under the, by quoting sections, it has been indicated. Now, Milord, there are activity head, subject activity head. Now, proposed, Milord, this is very important, proposed. Now, Milord, the power my lord of reconstruction in my respectful humble submission under the Kolkata Municipal Corporation Act is vested under section 396. Is vested under section 396. 394. Now, my lord, may I kindly takes up my lord page section 396 for a moment. 394 for once. What is 394? Well, 394 is an application for addition to or repairs of building. Every person who intends to execute any of my lord has gotten intends to execute the work specified in clause B to clause M of subsection 1 of 390. What has got? Well, every person who intends to execute any of the work specified in clause B to clause M of subsection 1 of section 390 shall apply. Milord, this is application to be forwarded. And Milord, sanctioning, Milord, kindly turns to 396. Milord, the sanctioning is with the municipal commission, and the section is the municipal commissioner shall. Milord, it is his duty to sanction. Nobody else.
Mr. Chatterjee, what activity is being delegated? Look
Look,
at the circular again. What is the activity?
My lord, kindly takes a minute, kindly turns over the activity, my lord, kindly turns to page I have indicated. Kindly turns to page 11, my lord, that will be a, my lord, better page. Sanctioning and issuance for building plan proposal, building problem. My lord, this is subject activity, my lord will find head. My lord, initially, my lord find 3 head, but this page doesn't have the 3rd head. It is starting from the 2nd head. Now, my lord, kindly sees under section 393, 394 of the KMC Act 1980. Now, my lord, in that, my lord will find the executive engineer's powers, executive engineer of the concerned borough for area up to 500 square meter for all other cases, executive engineer of the concerned borough for area 500 square up to 1000 square meter, height limitation is that 10 meters for all categories, executive engineer of the concerned borough for all other cases upon recommendation and compliance of MBC, member of board of councils, for cases dealt under section rule for 142 executive engineer. Now, my lord, why I draw my lord's attention to this? My lord, this is under 393, 394. My lord will find from the first page, the subject activity head, page number 9, site inspection, report inspection under 394. My lord, kindly see subject activity, site inspection report of the proposed building. My lord, 394 is the authority where you apply. My lord, it has been delegated to executive engineer very well, just like my lord Panchayat Act considered I was arguing. My lord, Zilla Parishad is up to 500 meters, Panchayat Samiti up to 300, and my lord Pradhan up to 100. My lord, when it is 510 meters height, application is to be made before the executive engineer building, and inspection report will come from his end.
Later. Mr. Ghosh, why don't you do this? We don't want to go into all this.
I am submitting to your lordship, my lord.
Please listen to what our suggestion is. He has said he has made a representation which is pending. Give him a hearing, dispose it off.
There is no difficulty, but my lord is taking your lordship to different angle, which is not the issue here. Because here in this case, the executive engineer exercises the power under section 410 and rule 32E. That I have referred to.
My lord,
And they, my lord, whatever the another construction was there, that is the exercise power by the structure of the building.
my lord,
Then
for a
the
moment,
order is
kindly see 3-2 in once. My lord, can he?
You dispose of his representation after giving him an opportunity of hearing, and to you, both of you. Esho. এগুলো তো কি রিপোর্ট আচ্ছা আগে লিখে নাও এটা রিপোর্ট ফাইলড রিপোর্ট ইন দ্য ফর্ম অফ অ্যাফিডেভিট এটা দাও ভাই মেমো কিছু দাও আমাকে
মানে পার্টিতে আমরা করে আসি
report in the form of affidavit filed on behalf of Kolkata Municipal Corporation. We kept with the records. Paragraph. This appeal is directed ওই আগে প্রথমে সবসময় করি যখন appeal disposed of হচ্ছে সবসময়। This appeal is directed against a judgment and order dated May 18, 2023, whereby the appellant's writ petition, appellant's S এর পরে apostrophe দেবে, appellant's writ petition being WPO number 1144 of 2023 was dismissed by a learned single judge. Paragraph. The writ petitioners had approached the learned single judge contending that in spite of complaints having been made to Kolkata Municipal Corporation, bracket in short KMC, bracket closed, comma, intimating that the private respondents have made unauthorized construction at premises number 52 by 1 Surendra Banerjee Road, ward number 50, Banerjee Road, comma, ward number 53, comma, Boro-Roman 6, comma, PS Taltola, comma, Kolkata 700014, comma. There was no action was taken by KMC. Stop. Paragraph. On the day the writ petition was taken up for hearing and disposed of by the learned judge, comma, learned advocate representing KMC submitted that he was yet to receive instruction in the matter. Paragraph. The learned judge took on record written instructions dated May 17, 2023, comma, issued by the officer in charge, comma, Taltola Police Station, comma, Kolkata, comma, to the learned state advocate, state capital. Stop. The instruction was to the effect that the construction done at the subject premises has been found to be in accordance with the approved reconstruction and demolition sketch plan. Stop. Such instruction was given on the basis of a communication from the executive engineer, bracket C, bracket closed, oblique building, capital H, oblique Boro-Roman 6, comma, building department, comma, KMC, comma, to the officer in charge, comma, Taltola Police Station. Stop. Paragraph. Taking note of the aforesaid written instruction, comma, learned judge came to the conclusion that the allegation of the writ petitioners that the private respondents have made unauthorized construction, comma, remains unsubstantiated. Chair fell, chair. No. Unsubstantiated. Stop. Accordingly, the learned judge dismissed the writ petition. Paragraph being aggrieved, the writ petitioners are before us by way of this appeal. Stop. By our earlier orders, comma, we had called for reports from KMC. Stop. 2 reports have been filed. Stop. A further report in the form of affidavit has been filed today. Stop. Paragraph. The appellants contend that the executive engineer, concerned executive engineer, did not have the power or authority to approve the reconstruction plan,
Not sanction.
sanction the reconstruction plan submitted by the private respondent. Stop. Paragraph Mr. Ghosh, learned,
My lord, one more, my lord, he has not even approved, my lord, from the report it is there.
আবার ওখানে আগেরটাতেই add করে দাও. It is further contended that the concerned executive engineer has not even approved the reconstruction plan, as a matter of fact. Paragraph, Mr. Ghosh, learned senior counsel representing KMC disputes the contentions advanced on behalf of the appellants. Paragraph, we are told that a representation, where is it? Is it on
My lord,
record?
my representation,
এটা দাও, স্টেটটা দাও।
my lord, it starts from page 101 to 28th of April 2023. My lord, and there are many following it up. একটা বলছি।
So shall we say this one?
My lord, 101,
Yes. Shall we refer to only this one?
yes.
This one
My
will
lord,
do
128 is more exhaustive. My lord can refer to
One?
page 128. That is more exhaustive, my lord, I would say.
128.
128.
Very well. We are told that several representations have been made by the appellants oblique writ petitioners to the competent officers in KMC, but the same have yielded no result. Stop. We find that a comprehensive representation was made on May 6, 2023, bracketed of page 128 of the application. Bracket closed. Stop. In view of the factual disputes involved, we are of the opinion that a competent officer in KMC should dispose of the said representation of the appellants by passing a speaking order, in accordance with law, after giving an opportunity of hearing to the appellants and the private respondents or their authorized representatives. Stop. Paragraph. Accordingly, who should consider Mr. Ghosh?
Talking about the executive engineer,
Ah.
matter to be heard by the director general building.
Director General Building. Accordingly, he is a party.
My director general building, party, কত নম্বর? 3, third, 6, 3, my lord. Respondent number 3.
Three. Accordingly, we direct the respondent number 3 herein, being the Director General bracketed building, KMC, to take a reasoned decision on the appellant's representation dated May 6, 2023, in accordance with law and the applicable rules and regulations, within a period of 12 weeks from the date of communication of this order, along with a copy of the representation dated May 6, 2023, after granting opportunity of hearing to the appellants and the private respondents or their authorized representatives. Stop. If the respondent number 3 finds merit in the grievance of the appellants, oblique writ petitioners, appropriate action will be taken by him in accordance with law. Paragraph, we have not gone into the merits of the disputes between the parties. Stop. The respondent number 3 will take an informed decision in accordance with law. Paragraph, since we have not called for affidavits, etc., etc.
Only one more thing, my lord, just indicate, my lord, since a report from the water department is also here, that is also erroneous. I have taken an exception. My lord, let that also be considered by the Deputy Director General Building, my lord.
If the respondent number 3 considers the reports,
That may not be considered by the director general building by your Nanagar once that is to be taken consideration, then the Director General Water Supply Department, because he is not supposed to consider the Director General Building is not supposed to consider that the water issue. Then it is to be considered by the Director General Water Supply Department, Water Supply.
No, but two reports were filed, one by the water department.
Another, because the Director General Building may not take into consideration the issue of water supply. Therefore, my lord, if that request to be considered, another reporter submitted, kindly pass this way. Since my reporter submitted from the water supply department, the representation shall be made with regard to that before the Director General Water Supply. That is to be taken into consideration in accordance with law.
You should make a phrase application, because what is your prayer in the drastic legal action against the accused persons and to conduct departmental inquiry?
Representation
If
Oh,
there
represent,
is-
my lord is look,
They are face some difficulty. You have to face.
128 প্রেয়ারের কথা বলছি। কি বলেছিস প্রেয়ার? Look, I can, my lord, because the allegations are of deviation, unauthorized construction, of which, my lord,
You should confine your allegation to that extent. Otherwise, it will be difficult for the
very well.
person to.
That may
Very
be
well.
recorded. Otherwise, my lord, consideration of the representation that includes that the situation. Therefore, it may be
It
confined.
may,
to that.
be, my lord, I
That
am
may
not
be
standing. in the-
clarified.
My lord, I will confine myself to the unauthorized part and the, my lord, power which they are exercising. My lord, and my lord, if that part of going into investigation, my lord can relieve me of that, my lord. Otherwise, my lord,
Do
the
you want to make, we shall clarify, or you want to make a fresh
fresh
representation?
representation, very well.
তাহলে
Try
এই
for
যে
it.
না, several representations yielded no result বলেছিলেন একটা জায়গায় খালি ওই representation, we grant liberty to the appellants to make a fresh representation ventilating their grievance addressed to the Director General bracketed building bracket close KMC within a fortnight from date. Stop. If such representation is made within the time period indicated, comma, the Director General building being the respondent number 3 herein shall take a reasoned decision, তারপর যেটা বলেছি, in accordance with law, etc., etc. Yeah,
My lord, along with then, also permitted to make a representative before the water department, that at
He may
that time.
also make a representative to the water supply department.
তারপরে এসে লাস্টে আবার বড় প্যারাগ্রাফ করে the appellants are also permitted to make a representation to the water department, comma KMC, which will also be disposed of. Who?
My lord, Director General, because my lord says
By the
water
director,
department.
by
Director
the
General.
Director General bracket the water department in accordance with law বলে সেম জিনিস বলবে, বুঝতে পেরেছো তো? হ্যাঁ ওটা
এখানে report
Director General building, এটা Director General water department.
I am led by Mr. Purito Sinha. I am led by Mr. Purito Sinha.
You are
I am led by Mr. Purito Sinha. I am for the state,
state. Oh,
led by Mr. Purito Sinha.
এই বইটা একদম ছিঁড়ে গেছে, এটাকে বাঁধাবার ব্যবস্থা করো, ফেলে দিও না।
করতে পারেন।
লাইব্রেরিতে পাঠাও, বলো কি করতে হবে। একটা আনাও না, ফেরত দাও, ফেলে না বাঁধিয়ে নিই।
ফাইনাল মামলা করতে তারপরে সে দেখা যাবে কি সমস্যা আর কি সমস্যার সাথে কি আছে
Three Lordship, I beg to appear on behalf of the
matter may wait for some more time.
Monday, judgment Monday judgment. will
Only
be
my lord,
delivered.
one indulgence, my lord.
It's ready. Or maybe tomorrow. We'll try tomorrow. If not tomorrow, Monday.
Only one indulgence, lordship. Lordship was kind enough to direct them, my lord, to bring all the necessary paper, my lord, before reaching into the conclusion that 408 is a, my lord, the only way, my lord, to deal with this situation. My lord, as senior friend, my lord, relied upon certain document. Lordship allowed us, my lord, to take exception, my lord, that is. Well, because they are outlining on the document. One or two scrap of document produced because nothing is there, my lord, they were preparing all this.
Exception of the appellant.
No, not the Kolkata municipal. I am appellant here, my lord.
This is your exception.
We have filed an affidavit disclosing certain documents.
Document.
The decision of the unauthorized construction.
Kolkata Municipal Corporation
There.
has filed an affidavit disclosing certain documents supporting KMC's action under section 400 bracket 8 of the KMC Act from 1980. Stop. Today, the appellants file
Yes, sir.
their exception
Yes.
to the said affidavit. Stop. Let the same be kept with the records. Paragraph. Let this matter stand adjourned till Tuesday date the other.
No, your lordship, 1 week, more 1 week, after that, whatever the decision comes, my lord, 1 week
Okay.
after that, your lordship.
Then Monday week. Monday week date the other.
Interim order, my lord, already.
কোথায় দেখি আমার দাও অর্ডারের ফাইলটা দাও
করলি ভাই
we have finalized it. We will not tell you what the result is.
only my lord, only my lord, it is a distinguishing, my lord. So for that case is concerned, entirely unauthorized construction.
We'll hear you.
My-
We'll hear you.
I'm also suffering from tension, my lord. Fate accompli, my lord, that being the situation.
Interim order is there till August 22. Acha. The interim order that is in subsistence will continue till the end of this month or until further order, whichever is earlier.
But I'm
Monday week কবে হতে হবে?
Monday week, my lord,
28th.
28.
But I'm submitting well, the OCOT which has been filed by us, well, that is not coming up on the last 2 occasions where I submitted.
এই আসছে না কেন? ওনার একটা ফাইল করেছেন ক্রস অবজেকশন।
এই যে নাম্বারটা লিখে দিচ্ছি
কতবার দিচ্ছি আসছে না কেন বলুন তো?
Let the ওই নাম্বারটা বলে দাও না।
COT 3 of 2023
Huh? Filed by Kolkata Municipal Corporation be listed along with this matter on the adjourned date.
Other side.
Case number 4.
May it please your lordship, my lord, I'm appearing on behalf of the appellant in this matter. Your lordship would recall that this is my appeal where my application to intervene was rejected, and I had pointed out before your lordships that in this matter relating to the Waqf board, the petitioners who claim themselves to be the Mutawalis have been disqualified by a valid order.
Foreign national or something.
Yes.
Your lordship, in this item number 4 and 5, I am for the responding Waqf estate, your lordship.
Yes.
I am being led by Mr. Arijit Chatterjee on his ground. I am paying for not to do, your lordship.
Why?
He's engaged in some other code which will take some time. So I'm only making it not to do, your lordship.
We are passing over. You are there, you will do the matter.
Your lordship, we have engaged Mr. Arijit Chatterjee to do the matter.
They have not engaged you,
Engaged me, your lordship.
then you will do the matter.
My lord, I must
Several adjournments were taken.
I completely agree, your lordship.
Put in instruction several, not one.
I completely agree, your lordship. But I'm thinking for today, not today, your lordship. This is the last time I'm paying for. Can you make it tomorrow?
I was requested by Mr. Chatterjee when I was coming up. Couldn't.
Can you make it tomorrow, your lordship?
Tomorrow. But tomorrow, kindly don't embarrass us by seeking adjournment again. If Mr. Chatterjee is in difficulty, you be prepared to argue the matter.
I'm grateful, your lordship.
Appellant. Now. May it please your lordship, Lord.
Wakaf. Very short point involved here, my lord. I am, my lord, on behalf of the appellant, private respondent in the writ petition.
Writ petitioner,
Writ petitioner, corporation, board of Wakafs have all been served.
No, I am appearing with the corporation. I am.
writ petitioner is there also.
Yes.
Board of Wakaf is there also.
There. Corporation. State has also been served. Now, there's the point in issue, my lord, is very short, my lord. I'll address your lordship, lord, only directly on the point in issue. Writ petitioner's name is recorded in the records of a particular municipal premises, my lord, of the corporation. Writ petitioner, my lord, at one point
The
of time,
company's name,
the company's name. The writ petitioner at one point of time, my lord, used to be a person holding under a lease. Subsequently, there were proceedings for his eviction, whereupon there was a compromise decree saying that he would be a tenant and his tenancy would continue up to a particular point of time. Thereafter, his tenancy did not continue beyond that.
He was a tenant under
The Wakaf estate.
Wakaf.
That's my client. Now, the writ petitioner's tenancy, my lord, thereafter, my lord, over a period, after the efflux of time, my lord, according to that document, was no longer existing. Under such circumstances, a suit has been filed for eviction of the writ petitioner before the competent civil court. Actions under section 54 of the Wakaf Act for removal of encroachment are also, my lord, in vogue in connection with certain actions done by the petitioners. The writ petitioners in this writ petition have sought a mandamus directing the corporation to receive taxes for them and to issue property tax bills in their name.
in the corporation records, their name is no more reflected.
Corporation records, their name is reflected. In my respectful submission, contrary to the statute, this came up for consideration in two writ petitions before this honorable court, whereby two different orders which have not been challenged, this honorable court was pleased to say that the name should remain as it is without deciding any of the other issues. I'll make my submissions on those. Now, armed with those two orders, the writ petitioner has filed this writ petition now wanting property tax bills to be raised in its name, and so that it can make payment of property taxes virtually being described as the recorded owner of the premises. It's nobody's case that he is the owner. It's not even his case that he is the owner. He is facing.
Banerjee, if his name is recorded as tenant in
My
the
lord,
corporation record,
There are only two things your lordship will kindly consider. Unlike the West Bengal Land Reforms Act, the Kolkata Municipal Corporation Act does not permit occupier mutation. Occupier mutation is alien to the provisions of the Act. The names and details of occupiers are kept in the inspection book.
before we hear you any further, allow us to go through the order. Let
Fine.
us see.
There's a,
Hey.
yes, there's a,
How much?
106 days, according to my. No, the review.
কারণ আমরা অভ্যস্ত হয়ে গেছি তো মাইক্রো কলেজ আসছে শুনতে পাচ্ছি বসছি হ্যাঁ
Sorry? You are opposing the condonation. Acha. Condonation is CAN 1. Condonation is GA 1.
Condonation is GA 1. কপিটা বাড়িতে রেখে এসছো?
Sure. Isn't that the way?
Advocate suffered accident. Very well, let's come to the,
My lord, one thing, my lord. Now we are accustomed with this system. I can follow my friend whom I like very much with Paul. I can't hear anything. He is arguing without any microphone.
আচ্ছা শোনো কৌশিক আমি যাই না দুটোর
আমি
বেশি-
সরে আসছি ওকে জায়গা দিয়ে তারপর আর্গুমেন্ট করছে শুনতেই পাচ্ছি না। আর শুনতে পাচ্ছি না তুই কি
আরেকটা
বলছিস কি
দরকার।
বল
আরেকটা দরকার, we are trying to organize extra microphone.
না কিন্তু তোকে না শুনতে পেলে কি বলবো?
But Mr. Banerjee, with great respect, you are on mic, you don't need a mic.
I but not the others.
Your microphone to
It's my pleasure to hear my very nearest and dearest. I read horrid. তোদের টেকিয়ে দে তাহলে সুবিধা হবে। আর my lord, every turn comes, I'll come. Turn comes,
We'll condone the delay, but let us read the order once.
Now, there's only one aspect, Lord, I must point out. There's an appeal from, there was a review application preferred before the Honorable Single Judge.
Review was dismissed.
The review was dismissed, saying that these are grounds for appeal and not for review.
That have you challenged that?
Yes, by way of a separate appeal, which has now been filed. That appeal is not there in the list today. I was requesting if your lordship takes up both the appeals together and then.
We'll dispose of the delay application today here. And we'll direct listing of the other appeal along with this appeal tomorrow or Monday.
They have not been served.
They will serve.
We'll
they will
serve in the
serve.
meantime.
Taken up together, my lord.
That's what I'm saying.
Yes.
Correct.
Yes, obliged.
And in any event, subject to my lord's wish, I do not think there is any scope for any ad interim order. The matter has to be heard.
Shall we hear out the appeal? The appeals.
There is a direction of the Honorable Single Judge by which the corporation would be in a position to accept money from the tenant. I would most humbly submit that if your lordship makes that subject to the result of the appeal and hears out the appeal, my lord, then my lord, I cannot stand it.
My lord will read the impugned order once. Consider for your lordship
We'll do that on Monday
on Monday.
Obliged.
or tomorrow, but whatever you say,
Monday, my lord, if it comes to your lordship.
Monday.
Monday.
Issue the-
আমাকে এই অ্যাপিলেটটা দিয়েছে, right?
This appeal is directed against a judgment and order dated February 10, 2023, whereby the writ petition of the respondent numbers 1 and 2 herein being WPO 1149 of 2022 was disposed of. Stop.
Service the other. Service the other appeal.
The operative portion of the impugned judgment and order reads as follows. Next. ও এটা ডিলেটা তো আগে লিখতে হবে তোমাকে, ডিলেটা কন্ট্রোল করে দিও কজেশন বি সাফিসিয়েন্ট করে, তারপরে অন্য ক্যানটা নিয়ে আর এপিওটিটা নিয়ে এটা হচ্ছে যেটা বলছি। Paragraph, we are told that an application for review of the aforesaid judgment and order was filed by the present appellants,
Yes.
by the present appellant. Stop, that application was dismissed by a judgment and order dated
13th April 2023.
April 13, 2023. Stop. Apparently, an appeal has been filed against that order dismissing the review application being, do you have the number?
I've sent for the number.
Being
but I-
blank, করে দিও, নম্বরটা দিয়ে দিও. Stop. Let that appeal be listed. Let that appeal and the connected application, if any, be listed along with this matter on Monday. দিয়ে দাও।
The number is 269 of 2023. The appeal.
Along with this matter, huh? On immediately after this matter, along with Nagpur, immediately after this matter. One application disposed of
check,
to make the hearing effective.
কোনো সন্দেহ নেই। That's for a comment. হ্যাঁ, যে কথা বলছি।
So what is he fishing?
He's saying juicy clients,
Juicy clients.
করে কমে খাচ্ছে তাই জন্য।
Number one thing, I'm really very much that. Know this. Minor says, oh my, one day I was asking.
APOT.
All are being recorded.
I got it.
All are being recorded.
Oh,
269 of
Final.
2023.
no, this is not the bad thing. They will enjoy. After all, minor notice, I get some praise about the use of common areas. So I was arguing that case, my God. And on the very next day, when Justice next day, court was 70 days. My Lord Justice. Wait. And judge here to get that. Magic. How can you run? I'm sure. You said that was yesterday, one of when he was arguing to 18. I just told them just wait. Let me hear Mr. Banerjee. That's why I'm on. I'm getting
Grateful.
Well, I need my.
But earlier when we used to go to Mr. Banerjee's residence, he used to treat us with these wonderful Roshogollas whenever we used to go. Now, my lord, he has stopped that practice.
Khasni re, khasni people take care. My park na purate.
Out of concern for your health.
Perhaps.
Well, I.
7, my lord, is my appeal. There was a direction for your lordships, my lord, for the corporation and the private respondent to file separate affidavits in connection with the matter, which was disposed of by the honorable single judge at the motion stage. Now, my lord, they have done it. My lord, my affidavits in response, my lord, are ready. Kindly grants me an extension till Monday, my lord, so that I can come ready. I can file.
That has not been served up. I need a copy, my lord. I will direct the Calcutta Corporation to serve copy.
Who is corporation is not here.
Yes, my lord, I am waiting for the copy.
You are for the corporation. Your report is ready
Yes, I have filed, lord.
today.
And yes, I have.
Right? Who is the private respondent?
I have also filed, my lord. And copy has been served up.
Cynthia Bala.
Huh?
S. Bala. ALA.
There's some problem with the stitching. I don't know.
I'm doing it, my lord.
File it today. File it today. We are recording that you have filed.
Hey, Modika.
Dekho. Report in the form of affidavit affirmed on behalf of the Kolkata Municipal Corporation, as also the affidavit of the private respondent, comma, filed in court today, comma, we kept with the records, paragraph, Mr. Banerjee, comma, learned advocate for the appellant, requests for time till Monday date the other, for affidavit in reply being filed. Paragraph lists the matter on Tuesday date the other. Stop. In the meantime, let advance copies of the affidavit in reply be made available to learned advocates for the respondents.
Another thing, my lord, let him.
It has been served, my lord, through department. I will definitely serve.
I have not received.
I mean,
You are co-respondents. You have no right against each other, but go out, exchange your affidavits, have a cup of tea together.
yes. Yeah, I'll put it. No, previous.
এই তো চল
It says, কে বলছিল? KFC, oh. Yes,
Well, I'll not take much time my lord, today. We almost have completed. Only my lord, side my lord, two judgments of our court, my lord. One of which was placed by my learned friend while my lord the hearing of the review application. That was my lord relied on, and on such basis, my lord, he asked for the review of the order. Then that judgment, my lord, if your lordship finds it at page in the bunch, a bunch to the bunch to the judgment is at page 57. Bimal Chandra Saha. In fact, my lord, on such basis, my lord, he filed the application and paid for my lord the review of the order. And this judgment, if your lordship will find that based on my lord, the judgment of Hon'ble,
yes.
basically come to page, my lord, 63. Yeah, convolution is পিছনে তো start হয়েছে। The court proceeded to decide the case, my lord, having due regard to the judgment, my lord, delivered in Hon'ble's case. And if you logically pay, find, my lord, page 63, the paragraph from Hon'ble has been quoted, paragraph 15. Sixteen. And 17. Well, I have all since I have, my lord, already, my lord, made my submissions with reference to the judgment of Hon'ble. Therefore, I did not repeat, my lord, once again that submission. But what I am placing before lordship, my lord, that the honorable judge, my lord, the honorable justice Harish Tandon, my lord, in fact, my lord, did not, my lord, give any separate reasons to allow this application, disposing of the Arijit petition solely on the basis of that has been considered by in the Hon'ble's case. Then ultimate paragraph is there at page number 67. If the corporation feels that the said property has an importance of any for any purpose indicated in the aforesaid sections, it is open to them to take steps in accordance therewith after affording an opportunity of hearing the petitioner. The question is, my lord, the declaration part may not be cancelled. The litigant, my lord, if he has any, my lord, say with regard to the declaration of the heritage building, he of course have a right to approach the authorities, my lord. There is a particular section is there to say that the declaration which has already been made may be cancelled. That is also the order of my lord, Mr. Justice Boshak in the case of Putti. Now, illogically come to the next document that has been, my lord, relied on here. The next case, which is at page 69. This case also decided by the Honorable Justice Amrita Sinha in the same way as was decided in Kamal's case. Lordship, kindly find page 72. The petition also relied upon the judgment delivered by the Honorable Division Bench of this court in the matter of Kamalde and the unreported decision passed in the case of Bimal Chandra Saha. You kindly come to page 77.
Yes.
Page 77. The said 12 documents relied upon the KMC in the matter of Putti have not been placed before this court. But that is not the correct recording of the fact. Moreover, the decision of Putti did not take into consideration the decision delivered by this court in the matter of Bimal Chandra Saha. Bimal Chandra Saha relied on Kamalde. And Kamalde, so far as the Kamalde is concerned, I have placed relevant paragraphs to your losses.
No, that's all right. No, Mr. Ghosh, please come to page 78. Running.
78.
Running.
Here, my lord, I submitted to your lordship on the last occasion that the court, my lord, while passing this order, said that the acceptance and adoption of the entire is en masse does not amount to compliance with the provisions of the section 425B. In that, for this reason, my lord, we took out an appeal.
Against this, you preferred an
Against
appeal.
this appeal, particularly because of this, my lord, the observation and recording of the
Which observation?
this, my lord, the en masse, my lord, cancellation of the entire list.
Yes, this resolution adopted in the meeting held by the HCC on 27 July, glaring example of total non-application, mechanical decision, resolution set aside.
No, that is, my lord, with regard to Yusuf Khan's case, because my lord, Mr. IP Mukherjee in the earlier proceeding was pleased to give a direction upon the authorities to consider his case as afresh under section 425B. The authorities, my lord, made a mistake, my lord, instead of considering the afresh, they took out a decision which had already been, my lord, not accepted by this court so far as the Yusuf Khan case. Therefore, the court observed so far as that case is concerned, whatever the decision was taken in terms of the court's order, that was not strictly in adhering to the directions of this court. Therefore, that was not cancelled. But we, my lord, after that, my lord, the court, my lord, we, my lord, challenged this or part of the directions here, page 78, first paragraph. Accepting the adoption of the entire list en masse does not amount to compliance with the provision of section 425B. Therefore, while considering the particular case, the court, my lord, went into a observation has been made in respect of the entire list.
Yes. And the appeal court clarified that this
I
portion.
fact that this should be considered individual, the case which is before the court, not more in respect the entire list. That judgment is, my lord, at page, next document, next, at page 180 it starts.
Hmm.
Therefore, my resolution submission that individual cases to be maybe considered. But here in this case, if you logically finds that the petitioner came to this court, my lord, after the gradation list was being prepared, or he has been completed so far as 22 parcels is concerned. And he is the post-declaration purchaser for the lessee. These are my submissions.
You will finish off today.
And we have prepared a written notice of argument, but after completion, I am to see, my lord, afresh.
We'll keep another date, no problem. Please also address on that law point.
Review.
Mr. Mukherjee is
Well, I think the civil procedure code will give your lordship the sufficient answer. No, we need not, whatever there has been, the judgments that Mr. Ghosh has cited, 4 judgments on the point that if there has been a review and if there is an order in review and the party who had applied for review has not appealed against the order by which the review application has been dismissed or disposed of, appeal from the original order is not maintainable.
Dismissal of review is not appealable.
So, will kindly take the civil procedure code. Mala, when I wasn't here when this argument was advanced before your lordship, I was quite taken aback. And in the previous matter, I also heard that there's an appeal from a review, which your lordship has been directed to be listed in the other matter. Well, kindly take order 47, rule 7.
Well, it has to be listed,
Yes, of course.
even for dismissal. Order 47.
Rule 7. Order 47, rule 7.
এই এটা কি ভাই? এই rule 7 তো নেই এখানে। তোমার আছে?
এই জজের দ্বারা সিপিসি সিপিসি হলে Well, is there any, should we?
Oh. Hmm.
May I read it out for your lordship's convenience? Tell. Look, the So, well, the doctrine of merger would only apply when there has been variation to the original order made in review, or portions of the order has been recalled, or the entire order is recalled, or the order is varied in review. Then the doctrine of merger applies, and then the review order becomes appealable. Lord, I just, if your lordship takes the paper book, page 370 is the order. Page 307, I stand corrected. Not 307 is the order of review. Your lordship will see. Third volume, page 307. এবার ওইটা দাও 16 My lord, at page excuse me. My lord, at page 309. The review stood dismissed. My lord, the ground on which we sought for the review was that there is a judgment of a coordinate bench considering Kamolde and these documents. So that judgment would be binding. So either the learned single judge ought to have taken into consideration, referred it to the larger bench if he deferred, but the honorable judge was of the view that it did not consider, so the review application was dismissed. So we could not have appeal because there is no appeal from order dismissing a review application. Even my lord, the latest patent appeal under clause 15 is not maintainable from a review dismissal of a review.
Why do you say so?
Because this was a view that even if there is no review under order 47 rule 7, there is an appeal. There is a possibility if it's in a civil jurisdiction, ordinary civil jurisdiction, there could be an appeal under clause 15. So this was held finally that no, there is no appeal within the meaning of clause 15 of
Give
the
that judgment.
Very well, I'll get that judgment as well. But that eventually it went to the full bench of the Andhra Pradesh High Court. But in any way, my lord, if your lordship will see here, if your lordship will see the writ rules, the civil procedure code, so far as procedure is concerned, has been made applicable. So here, my lord, our intra-court appeal in the writ jurisdiction is based on the writ court rules. Writ court rules টা এনেছে? আরে original side rules এই তো writ court rules টা আছে। Looks here. So, my lord,
It's possibly 53 or something, rule 53 or
yes,
one of those later rules.
yes, where intra-court appeals is provided in the writ rules itself. And the civil procedure code is made applicable so far as rules and other procedures are concerned. So when the order 47 will be made applicable, writ rules are the other procedures. So even otherwise, the clause 15 principle, though I will give your lordship that judgment, I'll make this a part of my compilation, where it has been held that, my lord, clause 15 appeals would also not be maintainable. If my lord will take one of the judgments cited by Mr. Ghosh, there is a judgment which has been cited by Mr. Ghosh, which is reported in 2016 to Devin. I was told that copies were handed over to your lordship. 2016, 4 Supreme Court cases.
ওই আগের দিনের নোটটা দাও বাবা।
This is Busa Overseas and Properties. I was told by my junior that copies were made over to you.
Yes, they were.
Huh?
2016 4 SCC.
My lord. 696.
In all fairness, this was actually supplied by Mr. Banerjee.
Okay. Okay. This, what he had cited, this will also stand in the way when his matter gets listed before lordship on Monday. 2016 4 SCC. পেয়েছেন? এরকম দেখতে হলো কি করে?
2016 volume 4 SCC. Oh, no. 2016 volume 4 was actually, citation was given by Mr. Banerjee. Copy was given to us of AIR 64 Andhra Pradesh, AIR 63 Supreme Court.
One copy.
একটা কি হবে? একটাই হবে না।
ওইটা আনতে বলো। Gotcha. Just Lordship kindly gives me a moment, my lord. You send for the second copy. I could have given you Lordship mine, but mine is extensively marked.
That doesn't matter. The only problem is once you mean your copy, Xerox copy.
No, we've sent for a photocopy, my lord. At a face check. Eight.
I thought you wanted to.
You've given one copy.
I thought you wanted to hand up your iPad.
No, my lord, we've got one photocopy I've sent for the book. So your lordship will give the second photocopy.
Don't want to give the iPad.
Well, iPad, then I'll be equally blind because mine relevant paragraphs with notings are recorded here. Classify. May I start with one? It should be here any moment.
সাহেবকে দাও, আমি শুনছি। Which are the relevant paragraphs?
My lord, the ultimate relevant paragraph, which is for our consideration, is paragraph 29. This is the ultimate paragraph. But you know, the discussions, my lord, which had led the Supreme Court to arrive at this paragraph, also, my lord, your lordship will also, my lord, kindly consider those paragraphs also. All the judgments on this issue was considered threadbare. My lord, starting from 54 Supreme Court. And my lord, there was a subsequent division bench judgment of your lordship, unreported, was also relied upon, I am told, by Mr. Ghosh. Where your lordship is considered, Shetaur in the Banerjee. No, who had given that judgment? Yeah. So Mr. Ghosh did not cite that, so why should we cite that?
No, he cited it after Mr. Banerjee gave.
No.
There was an unreported judgment in Kajol Mujumdar versus Sheikh Mansoor Ali, which is a division bench judgment of your lordship, is reported in 2023 SEC online Calcutta 239. Your lordship doesn't have recording of that. So that means they have not cited it.
No, they have not.
Very well.
That is on review.
Well, not on review per se, but your lordship was considering a review by a authority, not by a court order. Authority. It was a demolition order of the building tribunal. There was an appeal from a demolition order passed by the special officer. So there was an appeal, then there was a review. So there was no opportunity given and it was dismissed. So on that context, your lordship had considered it. Well, this is the 2016. This is the second copy of the 2016.
Oh.
Well, kindly take page 710, paragraph 29. My lord, needless to state that when the prayer for review is dismissed, there can be no merger. If the order passed in review recalls the main order and a different order is passed, definitely the main order does not exist. In that event, there is no need to challenge the main order, for it is the order of review that affects the aggrieved party. So, my lord, this is what it is. And my lord, if your lordship will go back, and in your judgment, your lordship has considered a judgment called Ripa Sharma, which is 2013 2 SCC. And my lord, your lordship will also consider there is a consideration of a judgment at paragraph 19 called Vinod Kapoor.
19 of what?
Para 19 of this judgment.
This judge. Vinod Kapoor, yes.
Vinod Kapoor. There is a judgment which is considered Vinod Kapoor, which is 2012-12 SCC. At para 19, your lordship will find the quoted paragraph.
SLP is also not maintainable.
They are saying that it's a plenary power of the Supreme Court under Article 136 is a plenary power. Your remedy, they're saying, is to proceed in the main appeal from the main order. But kindly take the quoted paragraph 11 in under para 19 in Vinod Kapoor. The quoted paragraph is there, para 11. Well, kindly see the first sentence of the set out para 11 of Vinod Kapoor. Para 19. It says, moreover, as your lordship found.
Yes.
Yes. On the High Court rejecting the application for review of the appellant, the order rejecting the application for review is not appealable by virtue of the principle of Order 47, Rule 7 of CPC. In Shankar Motiram Nale, such and such, cited by the learned counsel respondent number, this court has consistently held that an appeal by way of a specially petition Article 136 is not maintainable against the order rejecting the application for review in view of the provisions of Order 47, Rule 7. There is nothing, though we are not at the apex.
Therefore, SLP is also not maintainable.
And my lord, this has gone, and my lord, if your lordship will see, after considering all the judgments, and then my lord, again, Queen versus Letham has been referred to because there was a judgment which says otherwise, which was a judgment in 64 Supreme Court on the facts of that case. Well, that your lordship will find at paragraph 24. Because this was cited to say it was maintainable. Para 24, the aforesaid decision in Thangabhadra Industries, when properly appreciated, clearly reveals that it pertains to the stage when objection is to be taken. It does not lay down that a special petition against a review petition is maintainable or not. The focus on the stage of taking objection is fact-centric but not principle-oriented. To elaborate, the said decision does not lay down as a principle that the court is bereft of power to hear on maintainability. If we understand the view expressed therein, it can be said that the court has been guided by the concept of propriety. In this regard, we reproduce the statement in the law laid by Lord Halsbury in Queen versus Letham. So, my lord, Queen versus Letham is set out. Then on ratio, then my lord 26. My lord, kindly take para 26. Viewed in the backdrop of the factual score in entirety, we are of the considered opinion that the decision in Thangabhadra Industries has to be confined to the facts of that case. Then Mahendra Sari Emporium, which your lordship in fact had also considered. The jurisdiction of the court under Article 136. Then my lord, Ripa Sharma has been finally, court approves the view of Ripa Sharma. That your lordship will find at para 28. We have Vipashan 13.3 SCC. Why do we need this? For what purpose? He has shown this. So, my lord, my lord, reading para 28, 29, which is the concluding portion of this judgment, my lord, it can be safely said that, my lord, when there is a variation or the original order is recalled to any extent, then, my lord, the doctrine of merger will apply. Then the first principal judgment or the main judgment merges with the subsequent order, and then that becomes appealable. But if there's a dismissal of review for whatever may be the ground, not maintainable, considered dismissed, well, then the principal order remains, and order 47 rule 7 operates as a bar. My lord, ওরা কোনটা দেখিয়েছে? ওরা তো জজসাহেব বলছে দুটো দেখিয়েছে। Yes, yes, absolutely. My lord, there's no point repetition of judgment. My lord, this was the last judgment in 2016. There is nothing after that, and it considers all the judgment. And my lord, my learned friend had relied upon, I think, 62 Supreme Court.
63.
63. AIR 1963 Supreme Court 946. My lord, kindly have a look at that judgment. এটা আছে আপনাদের কাছে? And this is the other one that just see the this one. You have 4 countries. Let's see if it considers this one. Just sit and see.
Had 64. Yes.
Tell him to get a book, no? Or book test yeah. My lord, kindly consider 63 Supreme Court 946. My lord, allow me to place before your lordship the first two paragraphs. This appeal by special leave is directed against judgment and order of the division bench of Allahabad High Court, confirming those of a single judge of that court dismissing the application filed by the appellants to review the order of the High Court dated such and such. Now, my lord, there was a two, if your lordship takes para 2 once, the fact leads to the filing of the appeal may be brief. The respondent had held such and such agricultural properties in different districts, such and such in exercise of powers conferred on him under the provision of the UP Agriculture Income Tax, assessed the respondent to an agricultural income tax of rupees such and such. The respondent filed a petition before the High Court under 226 for quashing of the said order on the ground that the additional collector had no jurisdiction to make the assessment. In 1955, Mehrotra J allowed the writ petition by quashing the assessment. State of UP did not prefer an appeal against the said order and allowed it to become final. On 1956, State of UP promulgated the ordinance, subsequently replaced under the provision of the ordinance. The assessments made by the additional collector were retrospectively validated. Then, my lord, this gave rise to, then, my lord, if your lordship kindly skips a few lines from the top, then there's a paragraph starting with pursuant to the provisions of section 6. The appellants filed an application in the High Court for review of the order. It was the state's review, my lord. Based on the subsequent ordinance, the state of UP had applied for review of the original order. High Court at Allahabad for review of its order of 56. Subsequently, as stated earlier, the ordinance was replaced by UP Act 14 in course of the judgment as we refer to such and such. Section we correspond to section 6. Then, my lord, your lordship will kindly skip a few lines. Then, here was a point taken. They said application was heard in the first instance by Mehrotra J. And he held that section 11 of the Act, which corresponds to section 6 of the ordinance, did not entitle the appellants to file an application for review of an order made by the High Court under 226 of the Constitution. The appellant's petition was dismissed on the ground. The appellants preferred an appeal against the said order to the division bench. Chief Justice Muthan versus such and such was heard. The appeal dismissed it on two grounds. One was under Chapter 8, Rule 5 of the Rules of the Court, a special appeal against an order of single judge of the court can be maintained only if that order amounts to a judgment, and an order refusing an application for review not being a judgment cannot be the subject of an appeal on merit. That is on the construction of section 11 of the Act. The view taken by Mehrotra J was correct. Present appeal, as already stated, was preferred against the said order. But here your lordship will find at paragraph 3, one of the questions that fell for consideration is that whether the dismissal of the order was a judgment also within the meaning of clause 15. Well, these were the 3 points on which the special leave petition was heard. Malo, there's a discussion in the next page which considered our Calcutta High Court judgment in Justices in the Peace for Calcutta. Malo, whether what qualifies to be a judgment within the meaning of clause 15. All this is considered. Then the Bombay view is also considered. Now, if your lordship will kindly take just before paragraph 5 starts.
When did the amendment come in? The order 47, rule 7?
1976.
This,
I'll just once.
after this judgment.
After this judgment. After this judgment. So we're not even that. So that has been considered in the 2016 4 SCC, the amendment. And in fact, my lord, my junior rightly points out, I should have also pointed this out. My lord, if your lordship will see, this is no more res integra. Why I say this, my lord, if your lordship will kindly take once 2012, there's a judgment. 2012 6 SCC, page 782. Copy to the copy on it. Yes, sir. Is it there? Lord, kindly take para 25. I'll give your lordship a copy, my lord. I just took it out once. I'll just give you. I just place it and hand it over to your lordship. My lord, kindly once just take the. It refers to the different situation and what a party is entitled to do on the given situation. 3 different situations in review. When a review is dismissed on merit, or when it is recalled, or some addition or alteration is done to the principal order, what happens? Or there is a summary dismissal, what happens? My lord, kindly take para 25. Different situations may arise in relation to review petitions filed before the court or tribunal. 25.1. My lord, kindly take 25.3, which will be relevant for our purpose. 25.3 at page 791. It says the third situation with which we are concerned in the instant case is whether the revision petition is filed before the tribunal, but the tribunal refuses to interfere with the decree or order earlier made. It simply dismisses the review petition. The decree in such a case suffers neither any reversal nor an alteration or modification. It is an order by which the review petition is dismissed, thereby affirming the decree or order. In such a contingency, there is no question of any merger, and anyone aggrieved by the decree or order of the tribunal or court shall have to challenge within the time stipulated by law the original decree and not the order dismissing the review petition. Time taken by a party in diligently pursuing the remedy by way of a review may in appropriate cases be excluded from consideration while condoning the delay in filing of the appeal. But such exclusion of condonation would not imply that there is a merger of the original decree and order dismissing the review petition. 14 benefit I can take, but no more than that, on given facts, not at all times. But even if I take 14 benefit, you cannot argue that you're taking benefit of 14, so merger applies. So, but this is the remedy. I have to file an appeal from the main order. If I'll give you lordship the second photocopy. We've given one, the second copy. Now, if we come back to the 64 Supreme Court, your lordship will kindly take. So, my lord, after the amendment as has rightly fallen from your lordship, my lord, this becomes irrelevant at this stage. But still, I'll show your lordship, my lord, even this also holds otherwise. If your lordship will kindly take the paragraph just before paragraph 5 starts. The foregoing brief analysis just before paragraph 5 starts. All judgments are quoted, Bombay, Calcutta, Madras. Then, my lord, the foregoing brief analysis of the judgment shows that the definition given by the Madras High Court is wider than that given by the Calcutta and Nagpur High Courts. It is not necessary in this case to attempt to reconcile the said decisions or to give a definition of our own. For on the facts of the present case, the order of Mehrotra J would be a judgment within the meaning of the narrower definition or that expression. Then, my lord, your lordship will kindly see paragraph 12. Which paragraph? Paragraph 12. You decide upon paragraph? 12. Well, paragraph 12. Para 12. Lastly, it is contended that even if section 11 does not apply, we should treat the application filed by the appellants before the High Court as one made under Order 47 of the Code of Civil Procedure. There are many objections for allowing the appellants to do so at this very late stage of the proceeding. The application was filed only under section 11 of the Act and no attempt was made either before Mehrotra J or before the division bench of the High Court to ask for an amendment or to sustain the petition under Order 47. Nor did the appellant raise this plea in the petition filed in the specially petition or even of such and such. After the case was argued for some time and an observation casually made by the court, time was taken and for the first time this plea was taken in the additional statement of case filed by the appellants. This is therefore a highly belated attempt to convert the application filed on one basis into that of another. Further, the plea, if allowed, is not so innocuous or smooth sailing as it appears to be, but is brimming with many controversial questions. It raises the following questions. Whether the application treated as one made under Order 47 of the Code of Procedure was within time. If it was out of time, could the delay be condoned? Then 3, my lord, whether an order made by the High Court in exercise of its power under 226 of the Constitution could be reviewed under Order 47, and if not under 151 of the Code, whether the amendment of an act of retrospective. Well, these are the questions which was posed. Thereafter, my lord, kindly come towards the bottom after paragraph 5. The fifth situation. We do not propose to express any opinion on the aforesaid questions. It would be enough to say that we are not justified to allow the appellants to convert their petition to one made under Order 47 of the Court at this very late stage. So this remotely does not decide or it is not a proposition on the situation that an appeal has to be filed from the rejection of a review application. Well, this does not deal with the situation at all. And my lord, the two judgments that I've given to your lordship, my lord, completely is the proposition and the ratio on this issue. Judgment. There's a Andhra Pradesh, I'm told, which has been cited. Lord, that Andhra Pradesh, your lordship will see, that is also of 62, pre-amendment. And that also goes into clause 15 latest patent. And my lord, then if clause 15 is the judgment on, then my lord, Khinji's judgment will come in 81. So that will hold the field. So my lord, here, my lord, if your lordship will kindly see, my lord, here, if there has been a review and there has been a rejection of review today, as we stand today, if the Civil Procedure Code applies to writ proceedings before the Calcutta High Court based on the Calcutta High Court writ rules, then my lord, no appeal from an order would be maintainable in view of Rule 7 of Order 47 of the Code of Civil Procedure. So my lord, the only remedy that was available to us was to file an appeal from the main order. So this was our issue so far as the review issue is concerned. My lord, the entire my lord, if I have been informed correctly, because I did not have the occasion to be here when Mr. Ghosh was arguing, that Mr. Ghosh's entire thrust of the argument is these additional documents. And he says that the amended provisions or the substituted provisions of the Act has been followed. And this is what the learned single judge has held. So there is no scope for interference. And it is also, I have been told that Mr. Ghosh has also submitted that Komolde did not have the occasion to consider these documents. So since Komolde did not have the occasion to consider these documents, and the learned single judge did consider these documents, and after considering this document, if the learned single judge has come to a conclusion that the declaration has been in accordance with the provisions of the Act, there is no scope for an interference. In substance is the argument. So if your lordship will see, this argument is factually incorrect. First, my first submission is factually incorrect. My lord, Komolde not only considered, my lord, Komolde was a judgment which was delivered in the year 2016. My lord, your lordship will be surprised to note that the last document in this additional documents which was brought on record before the learned single judge, the last relevant document is of 2009. And in fact, there is a reference in Komolde's judgment to these documents. So, my lord, the onus, as I initially had said, ought to have been on them. Instead, the learned single judge had put the onus on us, because it was for them to satisfy that whether these documents were not. But that was my first argument. But then my second argument will be in reply that even if these documents are taken on record, what was decided in Komolde and the subsequent single judge does not alter the situation. These documents does not, my lord, contemplate a situation which was different than what was decided in Komolde. These are just documents which is reiteration of what had happened earlier in 97 and 98. There is no independent application of mind or any acts by any of the authorities, statutory authorities. Now they are discharging statutory functions under the amended provisions of the KMC Act. So, my lord, there is nothing which would transpire from any of these documents which would suggest that what was there in Komolde and what was decided in Komolde and has in fact been done in these subsequent documents. My lord, kindly allow me to, my lord, place the relevant portion of the subsequent documents. First, my lord, kindly, I will first place these documents and take your lordship then to Komolde. Or my lord, may I allow me to do it the other way around? My lord, Komolde, if your lordship kindly takes the trouble of looking at Komolde once. Komolde দেওয়া আছে তো। My lord, that compilation of judgment, পেজটা বলো তুমি। Where's my compilation? Your lordship will find Komolde starts from page 37. I hope I have the same copy. Tell me the page number. My lord, kindly take the trouble of once considering para 15 of Komolde, which would be at page 43 of the compilation. Well, your lordship will find at para 15 and a portion of para 11, which is page 42. If your lordship will take first page 42, where is that portion? Why don't you mark it? Yeah, give me yours. Horrible. If your lordship will see about, my lord, how many lines? About, I think it should be about 15 lines from the top. At page 42, there's a paragraph starting with by referring, and the previous two words from the left side is ecological purpose.
Yes.
Ecological, then your lordship will kindly make a note by referring. But here your lordship will find what has been referred to is a foreword contained in the volume 9 of the capacity building program published by the Kolkata Municipal Corporation, which was produced by Mr. Ghosh in course of hearing of this writ petition. By referring to such and such, Mr. Kaur, appearing in High Court administration, pointed out the High Court building was declared as a heritage building by the municipality, not on the basis of the recommendation, same argument and the municipal corporation, but of the expert committee is submitted. So, well, the foreword is off. Well, if your lordship will kindly now take the trouble of coming to para 15. Forward to off. Well, this is the foreword which was published. My lord, the first page your lordship will find as is at page 91 of the paper book. This foreword part. 91 to the 91 to follow. এইটা তারপরে আর ভলিউম 11 তো এটা my lord, your lordship will see, I will just hand over to your lordship the foreword. My lord, this is the foreword. এটা জজসাহেব this is the foreword This is the list. My lord, kindly turn to the second page of the forward. And my lord, kindly take serial number 12 towards the bottom of the next page. Your lordship will find reference to two dates of 2009. Well, your lordship will see there's a date of 25th of February 2009. Serial number 12 towards the bottom of the second page of the forward. Last entry, my lord. 25th of February 2009. Now, my lord, kindly have a consider, my lord, the list of document, the additional document, my lord. It is there, a part of the paper book, but for your lordship's convenience, we've just, the compilation which was handed over, we've given, which will have the full copy of the documents which was made over. My lord, kindly take the last document. So, my lord, or my lord, if your lordship will look at the index also, on the first page of the index, your lordship will find 25 to 2009 is the last entry, which is serial number 12 of the list. And it says, of this list of documents, the recommendation of Mayor and Council dated 21/1/2009 was approved by the Municipal Corporation, was approved in Municipal Corporation meeting. So there's reference to it in the forward. Now, but because why I said it, because an attempt was made to say that these documents were not there. Bold statement, nothing. No, this was not the manner in which it was placed before the learned single. I will take it for that it was not there. Or their argument was there, it was not there. My attempt, my endeavor is to show to your lordship it was there, all was there, everything was there, had to be there. Because the Calcutta High Court building's heritage status was under question. So corporation came up with every possible document they had with us. So everything was there before the High Court. So they could not have been a bigger matter than the Calcutta High Court building itself and before the High Court. So we are just a small building on the Park Street. And my lord, every possible department, including the High Court administration, was there before this court, before the division bench. My lord, kindly now look at paragraph 17. My lord, kindly take para 15 first, my lord, of Hon'ble. So this is the forward which is referred. My lord, kindly para 15. Let us now consider this part of the submission of the learned advocates of the respective parties to ascertain as to whether Chapter 22 of the Act, my lord, Chapter 22 deals with the building rules. What will be done, what is required to be done, you have to apply, do this, do that. So, my lord, what was under question is, my lord, that if it was a heritage building, then you could not have constructed or you could not have done anything. So chapter 22 would have no manner of application if it is a heritage building. So the construction which was being sought to be carried out in the middle portion was under question because it was a heritage building. So the High Court administration said it's not a heritage building. Though it is true that the High Court administration has not raised any dispute specifically with regard to the legality of the declaration of the heritage status of the High Court building by the Kolkata Municipal Corporation, but when the court finds that the document submitted by the Kolkata Municipal Corporation, that such declaration was not made following the provisions of the Act, then can the court proceed on the basis that such declaration having not been challenged specifically by the respondent, such declaration is legal and binding upon the parties? My lord, our specific answer to the question is no. The materials which have so far been produced before us by Mr. Ghosh, the learned advocate have already appeared, been discussed herein above. The foreword which was mentioned in volume 9 of the capacity building program published by the Kolkata Municipal Corporation, which was submitted by Mr. Ghosh in course of hearing of the writ petition, clearly indicates that the government of West Bengal, by its resolution of 97, constituted a committee to identify heritage building and sites in Kolkata Municipal Corporation area, and the expert committee submitted the report to the state government in 98. And after the said report having been accepted by the state government, the same was forwarded to the Kolkata Municipal Corporation for its acceptance and for taking suitable action towards preservation and conservation of those heritage buildings in terms of the Kolkata Municipal Corporation Act, and the building authority simply accepted and adopted the said report in principle. And my lord, kindly make a note of this word. But this language of the division bench, my lord, there is a reason for this, my lord. Kindly make a note of this language, my lord. Simply accepted and adopted the said report in principle and published a declaration declaring heritage status of several buildings, including the High Court. And the several building includes the writ petitioner's building. So that's why I say we are placed in the same situation as the High Court was in Komolde situation. So there has been no change, alteration, or any deviation from the factual position what was there before the division bench in Komolde. So I say that if you have accepted Komolde, and if there is no appeal from Komolde's, so my lord, the decision or the judgment delivered by the division bench in Komolde is clearly applicable to us, unless your lordships hold otherwise and refers it to a larger bench. So my lord, the report in principle. So then the division bench, your lordship, I don't wish to trouble your lordship once again in reply. So then the division bench specifically held that this has not been done in accordance with the provisions and accordingly was pleased to set aside. And then I was told they accepted this order and then went in to classify the High Court as a heritage building. So that though it is not on record, but I am being told this is the submission made, that it fell from your lordship, that what happened thereafter. So but the fact that they accepted the order and thereafter, my lord, they exercise, or then they started the process of declaring High Court, that by itself shows that the declaration of the High Court by this process was not in accordance with the provisions of the amended provisions of the Kolkata Municipal Corporation. And my lord, the division bench is no uncertain terms, my lord, has referred to 425 B and D, and in particularly D. My lord, D for Delta, where, my lord, which specifically says that, my lord, this is not just a pure mere consultative process. Discussions is not good enough. But the language uses, you have to scrutinize. Everybody has to apply the mind, because you're taking away a civil right, a constitutional right of a party to enjoy a property. Well, once my building is classified as or it is declared as a heritage building, I effectively lose my right of ownership. I cannot transfer, I cannot alienate, I cannot rebuild, I cannot demolish, I cannot do anything. All that I can do is that enjoy it the manner in which it is. Even, my lord, for repairs I also have to seek permission. So, my lord, when you are taking away a constitutional right of a party, my lord, enshrined under Article 300A of the Constitution, my lord, so, my lord, it has to be done in the manner prescribed in the Act. My lord, this is one aspect. So, my lord, my first submission is that Komolde squarely takes into consideration everything. Now, my lord, kindly have a look at these documents. In principle, your lordship has seen. I'll show your lordship. Kindly first take this compilation. And kindly take the document in the compilation, the fourth document of the compilation, which is 17th of April 2000. It should be serial number 9. আমার বই না, পুরোনো বইটা তো My lord, kindly turn to page 10. My lord, this is the minutes of the meeting of the Heritage Conservation Committee of 17th April 2000. If your lordship kindly takes paragraph F, well, the compilation, that compilation has a page number. Page 9 at page 10, paragraph F.
Paragraph 10.
F, mal, F. F for France. F. The committee. Para F.
Illegible.
Illegible. But I thought, my lord, it is legible. That's why because, my lord, your lordship will find that in the paper book as well. The page number in the paper book is 258. It starts from 258I. It's a typed copy. 258I at 258J. F. Paper book take to Deven. Well, this is the second volume. No, third volume. Third volume, same volume that I had referred earlier.
258.
It starts at 258I at 258J.
Yes.
My lord, kindly see, it says the committee. My lord, committee is the Heritage Conservation Committee. Also observe that all the buildings as recommended by expert committee formed by the government. Which is the government, my lord, state government, that expert committee of the state government, had been notified in the newspaper for consideration to include in heritage list. My lord, pausing here for a moment, my lord, the act does not contemplate any publication in newspaper. The present act that your lordship is considering, 425A onwards, chapter 23A, which was amended in 1997 December, this does not contemplate publication of any newspaper. So it is irrelevant if you have published in any newspaper or asked for comments from the public at large. Has been notified in the newspaper for consideration to include in the heritage list. The Heritage Committee now suggested that those should be listed as heritage building under the provision of 525B. 425B, I stand corrected. Well, this is a complete abdication of the power by the Conservation Committee. Even if this is my argument, is assuming that there was a committee. Because my next reply will be to your lordship that there was no committee at all. There was no Heritage Conservation Committee in accordance with 525B, 425D. Because 425D contemplates who will be the members of the committee. So the statute contemplates that these are the persons by designation and nomenclature, which specifically attributes that these are the persons which are required to be a part of the committee. There is no scope of any delegation. Or I replace A with B, no scope. This committee is a statutory committee. Even if one person was missing from the committee, as contemplated. So everything taken, all steps taken by this so-called committee is a nullity. And I will show to your lordship, this committee was not even constituted in accordance with 525D.
Mr. Bose, you did not argue this in your opening submission. Why I say this, then we have to give Mr. Ghosh a chance to deal with this. This is a very important point.
Yes.
But this wasn't argued in the opening submission.
At the my subject to correction, my lord, at the initial stages when we addressed your lordship, not during this period of argument, in the previous period when the matter was taken up, possibly, we did address it. In fact, it was addressed before the learned judge as well. That was, but then when Hon'ble was there, so this is another issue. So Hon'ble we went, or basically we say Hon'ble is holding the field. So if Hon'ble applies to me and the situation which prevailed during Hon'ble period applies to me, that will be enough. So be that as it may, this is also my argument that the constitution of the committee is bad. Now, if your lordship will kindly see once, suggested that those should be listed. This apparent suggestions given by them, is this part of paragraph F is wholly contrary to subsection 4 of 425D of the Act. Your lordship will also kindly appreciate today. So if this is the final court of the state, division bench. So whatever your lordship holds, whichever way, this finally, so this will be the, because after Hon'ble, unless of course they come up in any other subsequent proceeding with certain additional documents, then they say that it was also not there before the 2023 division bench. We've got some more document. So this some more document business has to stop. And they don't file affidavit being documents. So now it appears that the generosity that we showed to the corporation has turned out to be something, a major impediment for us. Because they brought these documents before the single judge, this is why we said that very well, we'll accept it. Because though affidavit, nothing came on affidavit. Kindly come back to subsection 4 of section 425D.
So are you saying that as on 18 April 2000, the Heritage Conservation Committee, the constitution of the Heritage Conservation Committee was not in accordance with subsection 2 of 425D?
If your lordship is looking at 425D, kindly take subsection 2 once.
That's what I said,
Yes.
2 of 425D.
Yes.
How do we get the constitution as on that day?
Yes. Your lordship has seen the forward, number 1, the forward which is before your lordship. Kindly have a look at the forward. Where is that page? No, that's eight. The constitution of the committee is there in the forward itself. Your lordship will see on top who are the members. After if I may just point out to your lordship, may I just?
Members, yes.
Possibly the 3rd page. I don't have a book. Boita nahi. Tomar kache forward ta ache. My lord, lordship will see nominee of the first person to be, or a person who is statutorily required to be on the part of the committee is the nominee of the Kolkata Metropolitan Development Authority. Subject to correction, not there. We haven't been able to ascertain.
Please, Mr. Ghosh, kindly note these points. He does not appear to be there. Also, Director of Department of Archaeology.
There's a remote possibility of person from the Department of Archaeology. Then,
Superintending Archaeologist.
yes.
No,
Department of Archaeology, Government of West Bengal.
you take one of these. Let us
Yes.
out. No,
My lord, may I have that one? If you, well, that is a marked copy, so it'll be easier for me to assist your lordship.
এটা দাও।
Who's his chairman? Who is chairman? Where is the chairman and convener? 7 others. My lord, kindly choose the 7 others. And my lord, there is a, if your lordship kindly turns to এই পেজটা কোথায় আছে? Well, with the designation, the publication, your lordship will see with the designation each person has signed. If your lordship will kindly take the compilation once, your lordship will find the designation of the exact name, designation, and the signature of the persons. That will make things extremely convenient. Well, this should be in the compilation, page 7 of the compilation.
Shomi Rokhit is what? Architect. Very bad handwriting.
My lord.
Artist.
Eminent architect, one shall be an artist. Your lordship will see, one is, the first person is Borun De. He is the chairman. He is signed as the chairman. Now, if Borun De is the chairman, then there has to be 7 others.
No, Chairman, State Heritage Commission.
Yes.
Member, Heritage Conservation Committee.
Correct. So if he is a member, he must be a historian. As we understand, Borun De was a historian.
Historian, yes.
So, Manasui, I'm sure he falls under F.
Yes.
F, okay.
Yes.
So this is F. Your lordship will next see. On the right is Professor Shomi Rokhit.
Architecture.
In what capacity he was member, we don't understand.
No, Mr. Ghosh says.
Now, my lord, kindly see, my lord, here. My lord, Rokhit, Mr. Rokhit was not a member of the committee. My lord, kindly see the forward. He was a member of the subcommittee. So there is no contemplation of subcommittee again in the act. So he said he is a member of the committee on top, and then it says he is a member of the subcommittee also.
It has been acknowledgements, members of the Heritage Conservation Committee.
And then your lordship will also find.
Shomi Rokhit, member.
So my lord, if I take him as an architect, Shomi Rokhit is an architect. So that see.
How do you know he's an architect?
I don't know. Well, from here, there's a stamp. Here he says, Shomir Rokhit. I don't know, is an architect. There's a journalist below that. So I understand that.
Who is the environmentalist?
No environmentalist, no artist, no KMDA representative. Nominee of the KMD.
Director of Department of Archaeology, Government of West Bengal?
How do you know? Director Archaeology and Museums, your lordship will see in this signature part. Dr. Gautam Sengupta, Director Archaeology and Museums. Then Anjan Mitra is Conservation Architect. So
Yes.
he could at best qualify as an eminent architect. Then there are persons who are not members have signed. And my lord, interestingly, your lordship will see, Anjan Mitra has been said to be a member. He's a subcommittee member. He's not a member of the committee. He's a subcommittee member.
Same with Indrajit Chaudhary. And where does a journalist fit in?
Not under 525D. There's no journalist. Does not contemplate a journalist to be a member of the committee. No.
Professor of Architecture.
And there is one gentleman by the name of Mr. Kapoor. Mr. G.M. Kapoor. My lord, Mr. G.M. Kapoor is a trained activist. He's an intact member. How is he a member of the committee? No, here it says a member of the committee. So, my lord, if your lordship will see, the constitution of the committee now also appears to be bad. You go. Wait, 2002 तक दिए जाओ sir. So based on a 2002 judgment, everything is a nullity. Two thousand. চলবে থাক না।
Four 25D
Minor.
subsection 4 contemplates framing of rules. Would you know if any rules have been framed?
No.
Have
Not
not
that
been
we are
framed, or you don't know?
No, my lord, we have not been able to ascertain any rule. There is nothing on record which has been brought on by the, well, it is only the if it is published in the public domain, we will know. There is no rule which has been ever published in the public domain. They have not brought to the notice of the court to suggest that they have taken steps for framing of any rules, or that any rule exists, or rules have been framed and they exist, nothing. So, my lord, if your lordship will now see, here if your lordship see, the suggestions are, and then my lord, if your lordship comes back to paragraph F, my lord, this is my, if there is a committee.
In the 2001 Act,
Fine.
under which the State Heritage Commission was constituted, 2001, I believe.
My lord, that was the Country Planning Act.
No. Heritage
Heritage
Commission.
Commission Act, yes.
There's a section which saves acts of a committee or the commission if there is defect in constitution. The Gonga clause, as they say.
Yes.
Here there isn't any.
There is none. And my lord, today. No. And my lord, all steps having been taken after the amendment. My lord, your lordship, in fact, your lordship, this fell from your lordship on the first day. What was the date of the amendment and when did the amendment come into force? My lord, it came into force on the 22nd of December 1997. So once the provision has come into force, and the, my lord, chapter 23A, there is no saving clause in 23A. Or it has no reference to the steps taken by the state committee. And in fact, my lord, there is no reference to the state committee or the Heritage Conservation Act also.
When exactly was the final declaration of these 800 and odd properties, including your property and including Mr. Banerjee's property, as heritage?
My lord, according to them, my lord, it was in September 2009. From the record that they have produced before your lordship, the final, what was one after the other, everybody started giving that final seal was given, appears to be in September 2009. That your lordship will find from the document which is appearing as a part of this compilation of documents handed over to your lordship at page 16. And it's a part of the paper book as well. No. 2009 এটা কোথায় গেল? No, I stand corrected, my lord. It was, I stand corrected, my lord. This was in the last page, 32. 32. 2009. এর আমার লাস্ট পেজটা কোথায় গেল?
So the approval of the mayor in council came on 22nd January 2009.
My lord.
That was the point of time or date on which final declaration took effect.
Correct.
As on that date, there was a Heritage Conservation Committee. You are saying, but we don't know the constitution. The constitution that you showed us
Yes.
was as on what date? The signatures, etc.
Malad, that was as on 2000.
But if the recommendation was made by a committee which was improperly constituted,
What they were considering was a recommendation of a committee which is not recognized under the amended provision.
that's what I'm saying. That's what I'm saying.
So that is number one. Well, number one, my lord, even assuming for the sake of argument that they could have considered. There was a recommendation by a particular committee. Very well.
Trying to understand, the declaration has to be by the corporation, 425B.
Yes.
Right. On the recommendation of HCC and of the MIC.
The three-tier process. The first tier also, if your lordship will see.
And this HCC
Yes.
mentioned in 425B
My lord.
must be a HCC contemplated in 425D too.
So, my lord, paraphrasing what your lordship just fell from your lordship, you constitute a committee in the manner prescribed under 425D. Once the committee is in place, the committee recommends, goes to the mayor in council. Mayor in council examines, gives its view, then sends it to the corporation,
This corporation means what?
municipal commissioner or the mayor. Apart from that, there is no corporation. Mayor in council is a body of the corporation. But this fell first day of your argument. He said, what would corporation mean? That's why your lordship will see the first, the last final authority of and the final clearance has been given by the mayor.
The definition is very helpful. 221.
Well, in fact, 221 was considered previous.
Excellent definition. It means the Kolkata Municipal Corporation.
Section 3 and 4.
Section 3. Yes, corporation, MIC, mayor. So this definition brought back to me in class 11 when I first took up economics.
Yes.
This professor came and said, how do you define national income? So you all thinking. And then he gave the answer himself. It's the income of the nation.
Which is subsection 21.
Yes.
Corporation means the Kolkata Municipal Corporation. The income of the nation.
No, Mr. Ghosh, what I'm trying to understand, you will assist us. You will have to deal with these arguments. HCC to be constituted under 425D. Under 425B or whatever section, HCC has a duty or power to recommend to the MIC that these are the buildings which ought to be preserved as heritage building. MIC will consider, if it passes that, it will go to the corporation. That is the final stage. In this case, when did the corporation finally approve the list? We want to know. 28th February 2000? 2001.
Correct, correct. ওটা দেওয়া আছে।
9. Where are you? What are you looking at?
September 2009.
What are you looking at?
Well, that compilation page 16.
Let us
Compilation
take,
page
let us take
16.
it from the paper book. 258. B.
P. P. এই তো দেখো। Correct. হ্যাঁ, কালকে দেখলাম না আমরা ওটা। হ্যাঁ, ওইটাই তো আমরা দেখছি। এইটা লাস্ট পেজটা আমায় দাও না, লাস্ট পেজটা নেই, এই তো এইটা।
2001 is a mistake. That was a annoyance.
হ্যাঁ, এই তো 9ই আছে, 9ই আছে। এইটা লাস্ট পেজটা দাও না আমার।
No, no, this is not final, Mr. Ghosh.
No, no, I'll
This is
tell you
not
what,
final.
Shimala, kindly see, MMA এর পরে কি আছে?
Anyway,
NN,
we'll,
NN,
we'll
258.
continue tomorrow.
Very well.
Difficulty? Monday? Wednesday? No, Monday, Tuesday, you said you normally have some difficulty. Wednesday? Wednesday, Mr. Bose?
Wednesday.
Wednesday.
Your lordship rises.
No, no, Wednesday কি সকাল হয়?
Sorry?
Very humble prayer.
See the microphone, Mr. Chatterjee?
Lord, a very humble prayer.
Yes.
Lord, items number 4 and 5, my lords have been pleased to fix it tomorrow.
Yes.
Lord, tomorrow, my lord, I am in grave difficulty, my lord. I'm not in Calcutta for some work, my lord.
Mr. Chatterjee, on a number of occasions, this matter,
Lord,
you said you need
Lord,
instruction.
Instruction. I've got the instruction. I have. He said, my lord, anytime next week, my lord, if it
Not
somebody.
fair to your learned friends also.
I
Mr.
spoke to Mr. Banerjee, my lord. I bow down, my lord.
When do you want it?
Next Thursday or Friday.
Next Thursday? 4 or 5, we keep bill ki skiye
My lord, the 3:30 preemption, man.
today.
Today there
No,
is a-
no, there was some confusion which we created. Our officers created. We didn't have it in mind that at 3 o'clock we have a different bench.
And 3:30 today also.
3:30,
But I will take a little bit time there.
when do you want it?
Keeps it on the 31st because I have to address your lordship. now.
31st?
31st. But this is a tricky question of law. I haven't been, my lord, able to satisfy myself as yet. 31. I haven't been able to satisfy myself as yet, my lord, to make a submission before your lordship.
31st বলছেন দেখো কিছু হবে কি? হ্যাঁ ফাঁকা ফাঁকা 31st what কি তারিখ কি বার কি? ঠিক আছে 31st 3:30. Kindly circulate this.
I'll Mr. Mojumdar. So
এই লিখে নাও একটা.
extremely grateful.
Mr. Ghosh, learned senior counsel representing Kolkata Municipal Corporation concludes his argument. Paragraph, Mr. Moinak Bose, learned counsel representing the appellants begins his submission in reply but does not conclude. Paragraph lists the matter once again on Kavebullam.
Wednesday date
That's
about
23, huh? August 23, 2023, for further hearing. অন্যগুলো
May I have your lordship's extreme indulgence to mention a matter regarding a 3:30 matter fixed today?
কোনটা ছিল আজকে?
Item numbers 31 to 33
Oh, no,
regarding
that
that change.
Mr. Onurudh Chatterjee has not informed you. He mentioned at 1:15.
There's a resolution of the bar, that's why I was mentioning.
31st. Anyway, he is in difficulty. 31st August, 3:30.
I'm so good. I'm so good.
I appear for the appellant. I'm for the respondent number 1, my lord, and writ petitioner.
1 second. Yes. Though all parties are here, Mr. Datto?
Yes, ma'am. State name? Oh, I'm told, my lord, the state and the election commission is not here.
Then the practice we follow is in the first call, if all parties are not there, we pass it over. In the second call, irrespective of their presence, so long as service has been effected.
Yes, service is effective.
Then in the second call, we'll take it up.
Yes.
Your lordship, Lord, this is my appeal, Lord, an application. Service, Lord, service on the private respondents is not yet very definite. So kindly let the matter, my lord, appear next week, anytime, Lord. Next Thursday, my lord, if it commences, your lordship.
Learned advocate for the appellants says that service on the private respondent is yet to be effected. Paragraph as requested, let this matter stand adjourned and be listed again on
Next Thursday.
date দিয়ে দাও।
Item number 3, my lord, I'm led by I'm for the appellant, my lord, and I'm led by Mr. Debabrata Share. He was just briefed yesterday, so I'm seeking for this week's accommodation.
Not this week. Record করে দিও দেবজিৎ on the prayer made on behalf of the appellant. Let this matter
Grateful.
stand adjourned for the week.
Grateful, your lords.
এই শোনো দেখো
Item number 4, lordship, I beg to appear for the respondent number 10.
That 5, I beg to appear on behalf of the private respondent.
Item number 5, I am for the appellant. But on 27th July, your lordship was pleased to direct the corporation, my lord, Howrah Municipal Corporation, to swear an affidavit annexing one report which was filed in the court below, but that has not been supplied as yet.
But I will supply, some time may be given. But actually, I could not have come to the court today also because my paternal uncle died. So, my lord, let me give it some at least 10 days time. I will file the report.
for 10 days you will not come to court.
I will come, my lord. I will come. I will always come. But tomorrow I will again go. Problem is there.
সেই রিপোর্টটা অ্যানেক্স করে একটা এফিডেভিট annexing that document, that report.
Mr. Banerjee, you already have that report.
I have that report. I will give it
Just-
on Monday.
Yes, just file it. Next Thursday,
Thursday.
next Thursday. Read order dated July 27, 2023, paragraph. Mr. Banerjee, learned advocate representing Howrah Municipal Corporation, seeks a week's time to file affidavit in terms of our order dated July 27, 2023. Paragraph, let this matter be listed again on Shamner Brishpativar. So on that date, the corporation shall file its report. Stop, let advance copy of the affidavit be made available to learned advocate for the appellant.
My lord, I beg to appear for the private respondent, writ petitioner.
Item number 7.
Passed over. Passed over.
For the petitioner in item number 7, appellant.
नहीं तो
Your Lordship, I am appearing on behalf of the appellant. I am led by Mr. Gunjan Shah in this matter. Your Lordship, he is on leg before the court
Pass
number.
over.
I am for the petitioner, my lord. Item number 14, I am for the petitioner, my lord.
Yes,
It's a legal aid brief and my lord, it's a change brief, so I need a week's time to prepare for the
Okay.
matter.
next Thursday kore daw.
Obliged, my lord.
My lord, I am appearing for the appellant, my lord. This appeal has been infructuous, my lord.
Which one, sir? 17.
17, my lord.
Learned advocate for the appellants says that this appeal has become infructuous. Paragraph accordingly, FMA such and such is dismissed.
Grateful, my lord.
I am but the private respondent.
My lord, 24 and 25, there are talks of settlement going on. My lord, will kindly keep these matters after a month, my lord, after 4 weeks.
Talks of settlement.
My lord, what had happened, my lord, this case?
No, we don't need to know. You just tell us, you're for the appellant.
For the appellant, my lord.
Learned advocate for the appellant says that the parties are negotiating to settle the matter outside court, out of court. Paragraph. As requested, let this matter stand adjourned and be listed again after 4 weeks. Date ta diye dao. Same order in 24 and 25.
25. I'm grateful, my lord.
Second call.
Second call, item number 1.
You didn't have to wait for long.
No, but I expected that.
Maintainability. Maintainability.
Two wise maintainability. Number one is, Milord, there are so many judgments, Milord, which says that,
We have recently delivered
Yes,
one or
yes.
two.
yes, this is number one. And number two, Milord, these kinds of orders are also, Milord, not passed, Milord, where, Milord, the writ court directs to file a report.
Who is for the writ petitioner?
I'm for the writ petition, my lord. My lord, the writ petition was challenging the issuance of a SC certificate. And thereby an order was passed by the London single judge, the honorable
Sir,
single judge.
it's still an election dispute.
I bow down to that, my lord.
Constitutional.
My lord, if I may. My writ petition was challenging the issuance of the certificate by the subdivisional officer. To that effect, an hearing was been afforded to the appellant. The appellant appeared before the SDO. The SDO has passed a recent order which they have annexed in their mat. If my lord may kindly take up page number 51. My lord, dear. Second last paragraph.
It's a show cause.
Yes, my lord. My lord, the leave was taken in this appeal after they have received this order, so-called notice. Primarily, they have participated in that hearing. After that hearing, the order was passed. When they was agreed by this order, then they filed this mat challenging that
Where is that order?
the order, impugned order, that so-called notice.
Yes, you say after the show cause notice, a hearing was fixed.
Yes.
She participated in the hearing, and then an order was passed after the hearing.
No, tomorrow there is a date fixed for the hearing.
Tomorrow is
the date. I'm not here before my lord to cancel the candidature of the parties. I am here that the particular department has issued a certificate. That certificate was issued in a manner by means of fraud and malpractice. That is all my grievance. That is it, my lord. And another thing, my lord, this particular.
What is your prayer in the writ petition? your prayer.
Yes, 29.
Cancel the candidature of the private respondent number 7.
Yes, my lord.
Then
But still, my lord, the
from
prayer B, my lord,
poll election.
prayer,
Sir, this is an indirect way of achieving what you cannot achieve directly.
I bow down to my lord.
If that is so, then you withdraw the writ.
But my lord, there is an authority
take
who have
it.
issued a certificate without scrutinizing it. If I lord allows me to place another point, this appellant was an outgoing member.
Sir, now that the whether it is. সেটা না সেটাই বলছি সেটাকে আমরা টাচ করবো
If their first prayer of the writ petition stands exists, then it will be difficult for you to argue before us that I am not.
But we did not place prayer A. The order was passed in terms of prayer B and C. If my lord may kindly takes up the impugned order also.
You are not pressing
No.
prayer A.
No, my lord.
Not
We
pressing.
cannot praise it, my lord. We cannot praise prayer A.
But
The
in that
candidature-
case, my lord, the learned single judge did not have jurisdiction otherwise also. Then it cannot be before the panchayat bench,
it will be where?
before the group 9 bench.
Group 9.
Yes.
But if
It has to go before the miscellaneous bench.
But
Sure,
it is in
sure.
connection with panchayat matter, the certificate was
No, no, no.
issued in.
Panchayat, the certificate was not issued under any panchayat law.
Correct.
My lord,
That
your
is true.
lordships. Yes.
My lord may kindly take up the stay
Otherwise-
application paragraph 2.
Go before the group.
I may, but I want to indicate that, my lord. My lord may kindly takes up the paragraph 2 of the stay application. Page number 4 of the stay application.
Yes.
When the certificate was issued to her, the certificate was issued to her prior to
Sir,
6 months before.
your grievance may be well founded,
Yes.
has substance. Go before the proper court.
I may, but my lord, I just indicating the backdrop
Why
of what
are
is
you
the writ petition
indicating
is about.
We will record you are not pressing prayer A.
Yes.
Right?
Yes.
In that event, then the learned single judge who passed the order is not the appropriate court.
Yes, my lord.
Or we can, to avoid complications, we can also do this. We can dispose of everything. You approach the group 9 court.
Yes, man. Then kindly that grant leave
Yes.
will be granted
We
to us.
make clear why we are disposing of,
Yes.
not on merits.
Amen.
We are not touching the merits at all.
Yes, man.
Issue. An order dated,
My lord, if one indulgence may be noted, my lord, the hearing that is to be taken up
That
tomorrow.
has to go, everything has to go.
My lord,
Everything
if that is there is a separate, because that is not related to the writ petition. The hearing has been
Oh.
called on the complaint, on the basis of a complaint. If my lord may takes up,
no,
not on the basis
if
of a
it
writ
is not
petition.
in pursuance of Justice Sinha's order,
Yes.
then we will not touch it.
May I say this, my lord?
But the hearing is taken up on the basis of a complaint, which is not related to the
What
order.
we are trying to say, why don't you understand?
fine.
We are saying if the hearing is not pursuant to Justice Sinha's order, then we will not touch that hearing.
No, on that note, I have got a jurisdictional issue again.
Yes,
The SDO does not have jurisdiction.
that you go and you challenge it then.
Yes, therefore, your lordships may kindly set aside the entire order.
No, that order, why will be set aside,
No,
Mr. Dattu?
Because if my lord, please consider one thing.
As I said,
Yes.
if you have challenged an order of the learned single judge before us,
Yes,
we are setting aside that order.
yes,
If the hearing was fixed in terms of this order,
Yes.
we would have set aside the hearing.
yes.
But that is not so. The hearing has been fixed, as we are told, on the basis of an independent complaint
Yes,
made before an authority who may not be the appropriate authority according to you.
yes.
For that, you have to take steps otherwise.
But may I say this, my lord?
Yes.
This is, my lord, the submission of my learned friend's client.
Yes.
It is for the state to say that whether it is an independent action or pursuant to the High Court's order.
Where is the state? Does the notice of hearing refer to the impugned order?
I am.
The show cause notice of hearing, nothing refers to the appeal.
Yes.
There was a complaint.
And my lord, that is relatable to my lord, your lordship is also fine. Their prayer C. Because their prayer C was.
Yes.
consideration of a representative.
Yes.
Lord, pursuant to that, Lord, the proceedings under the schedule card and schedule card anti-deficiency act was taken. And that is continuing. And I am trying.
হাইকোর্টের অর্ডার অনুযায়ী
resisting
হয়েছে
myself
সেটা
from making any comment on the merit of the hearing which is going on.
Yes, need not.
They need to thrash out their point before the.
Yes. If you say it's before an incompetent authority, challenge it. We are not touching that. We are disposing of these proceedings.
Very well, then your lordships may kindly not, my lord, give any observation as regards the hearing that is going to take place.
Nothing.
Well.
Nothing.
And all rights of all the parties kept open.
Everything, all points, all liberties, everything.
Yeah.
An order dated July 21, 2023 passed by a learned single judge of this court
সাথে হচ্ছে তোর order.
in WPA 16943 of 2023
Representation.
being a writ petition filed by the respondent number 1 herein.
I'm sorry, my lord.
Respondent number 1, writ petition filed by the respondent number 1
Yes, this one.
herein, comma, is under challenge in this appeal. Paragraph. The writ petitioner approached the learned single judge. Now, we are reproducing the order impugned, comma, which will speak for itself. For a colon দিয়ে এইটুকু order একটা করে দাও.
কাছে একটু সুপারস্টার কি করে ইয়ে করছে
Paragraph.
এটা সুপারস্টার এটা
The private respondent in the writ petition has come up by way of this appeal. Paragraph, Mr. Dotto, comma, learned senior advocate representing the appellant, oblique private respondent, says that the matter relates to an election dispute and therefore the learned judge should not have entertained the writ petition in view of the constitutional bar under section article 243O. Is it O? 243O of the Constitution of India, read with the provisions of the West Bengal Panchayat Elections Act 2003. Stop. Mr. Dotto also referred to various decisions of the Honorable Supreme Court, which have made clear that an election dispute can be only raised by way of an election petition before the appropriate forum. Paragraph, learned advocate for the writ petitioner says that on instruction, comma, he is not pressing prayer A of the writ petition, which reads as follows. Prayer A টা আমি তোমার এখানে এ করে দিচ্ছি, মার্ক করে দিচ্ছি, করে দিও। Paragraph. Mr. Dotto then points out that if prayer A is not pressed and is deemed to be deleted from the writ petition, comma, the learned judge who passed the impugned order would not have determination to entertain the writ petition. Stop. In that case, the writ petition will have to be heard by the learned judge who has determination to hear group 9 matters, Roman 9. Stop. Paragraph, Mr. Dotto seems to be right. Stop. The learned counsel for the writ petitioner has agreed to our suggestion that we may dispose of this appeal along with the writ petition by setting aside the order under appeal, leaving it open to the writ petitioner to approach the appropriate forum in accordance with law to ventilate her grievance. That is all. Paragraph, since we have not called for affidavits. Yes, yes, yes.
I have it with me. I have it.
Not necessary.
My lord, my lord, the hearing that is going on will be.
Maybe one
Touch, we have not touched it. We have said nothing.
Thank you.
Yes, so the writ is also disposed.
Yes, yes. Writ is disposed of. Treating the same as on day's list. Short and sweet.
Yes. Matter should be short like this.
Yes.
I am for the state.
Yes, item number 2. Manush Mukherjee. Oh, 4, sorry. Chilo. Eh?
I beg to appear for the respondent number 10, Lordship.
For the respondent number 10.
Chilo na. The usual order.
Das.
Actually, coming. Appellant, who is the appellant? We are dismissing for default and you are standing there.
No, my lord, I am coming from court number 18 just now.
No,
My
No.
lord, in this regard, my lord, your lordship's pursuant to lordship's direction, I have already served upon all the respondents, including the panchayat.
Yes.
So, my lord, service is not completed. I am praying
Better
only
the-
not this week, my lord. Only praying. Admission time, Monday.
I mean, seriously,
Just see the order, Mr. Ghosh. If there is no merit in the appeal, why should we wait? এইগুলো তুলতে গিয়ে তো কোমর বিয়ে হয়ে যায়, কবজি মুচকে যায়। আরে এ তো বিরাট অর্ডার।
But the improved order was first made on 386 on and from relevant portions in this. The improved order.
Yes, where is the impugned termination order? April 20.
That dismissal order, rejections of the service has not yet been communicated, but this dismissal order was communicated by the concerned block development officer. From the
It is not on record.
No, it has not been communicated. Even
But-
that we have also prayed for the certified copy.
But
No,
that,
No, it is annexure R4 to the affidavit in opposition. What are you saying? You are not ready.
Only well, a few seconds, well, petitioner must have physics and mathematics.
You are for whom?
I am for the
Private.
Private respondent.
Well, a very short point. Well, this is his own handwriting that he wanted to cancel his name. Well, kindly see for a moment. And
Mr. Ghosh, we want to see the termination order.
only on this reason, BGO, he submitted a written representation to the BGO that I have no mathematics and physics in class 12. So I have no eligibility criteria. This is his own handwriting of the applicant.
no, combined subject, including the mathematics as well as the physics. Both are availing of the person. But in 2012, prior to that, we have. But that rulings and notification has not yet been applicable to those cases. When after 12, he has been passing with the vocational of the higher secondary, and he's obtained the physics and chemistry being a combined subject. That subject cannot be applicable to the present case. Because earlier I have already passed and also produced all the records. And after that, I have been selected. Even this, my learned friend's client is appointed much earlier, not in this post, but also the other post. But he has been filing this writ petition. Even that without prior permission of the government, he has been proceeding before the Panchayat, and Panchayat has taken the selection process. That was not successful or failure. After that, writ petition was filed, and we are made a party in the said writ petition. That writ petition was heard by the district magistrate, and accordingly we say that the concerned magistrate has been said that found that the physics and the mathematics are not combined subject of the candidate. Accordingly, his service has been rejected.
Block development officer, used an affidavit, but annexing the letter issued by the applicant.
Even that,
That he wanted to cancel his name.
the matter of right, the learned trial judge has already been dismissed this writ petition only on the ground that the contractual appointments is not applicable to under Article 226 of the writ jurisdiction. So I have one judgment of the Supreme Court as well as the learned single bench of the division bench of our High Court. But I have, because it has been entertained, but only in scope in regard to this under Article 226 is not applicable. It has been also crystal clear in the impugned order. Last.
Stipulation to equal annexure করেনি কিছু জিনিস কিছু নেই অনেক আশেপাশে ডকুমেন্ট নেই
You did not have physics.
No. Well, this is the government circular and this is the own right
That government-
of the applicant.
That government
That he
circular
has
is
no
not
physics.
applicable to my case because earlier I have already passed. Whereas the physics and mathematics I have the subject. Whereas the selections committee has been considered and I have been appointed.
Anyway, let it.
Your Lordship's candidate next week, any day,
Yes, come prepared.
Well.
We'll probably dismiss it, but then you will have the pleasure of arguing.
Kindly see this, only handwriting of the.
We will see. What makes you think we will not hear you, Mr. Ghosh?
মন মেরিটে দেখা যাবে।
কিছু নেই পেলে। Heard Mr. Advocate for the appellant. Stop.
Certain these documents had not been annexed. I can use the affidavit by tomorrow.
He does not conclude. Paragraph lists the matter once again on next Wednesday. Tariq diye dao. Stop. Paragraph in the meantime, comma, learned advocate for the respondent number 10. Nah, in the meantime, the respondent number 10 will be at liberty to file an affidavit annexing copies of documents on which she wishes to rely. With advance copies of such affidavit to learned advocates for the other parties.
Instead of Wednesday,
Thursday করে দাও, Wednesday বদলে Thursday করে দাও।
No, I am sorry, my lord, hey, regard to this agent of that ballot at the time of call, because I was engaged in other court, my lord.
In this matter, I am for the Howrah Municipal Corporation.
I am appearing for the private respondent, writ petitioner.
The last,
Mr. Gupta is for the appellant. I was praying for a day's accommodation.
I can't hear a word of what you are saying.
Lordship, Mr. Gupta is for the appellant. I was praying for
Mr.
a day's.
MP Gupta,
Yes, Lordship.
yes. Where is he?
He is not available in court today, Your Lordship. I was praying for a day's accommodation.
He's not in court,
Oh, Your Lordship.
not today.
only last occasion, your lordship directed me to see how much demolition was done in the earlier occasion. I have.
Tomorrow you'll come, Mr.
I
Banerjee.
will come. I'm giving a copy of that.
Give it to Mr. Gupta. Give to others also.
You have already got.
আচ্ছা তাহলে একটা order করে দিয়ে যা। We had directed to file you a report. Directed you to file a report.
My lord, I am filing it by.
Lord, the comprehensive report was to be
দিতে
filed.
বলুন।
They are filed.
To give the measurements of demolition already done. That report, my lord, has not got. Report ধরে দিয়ে দিন।
By our order dated August 2, 2023,
কাল করবেন না সোমবার?
we had directed Howrah Municipal Corporation to file a report indicating if the corporation has already demolished certain portions of the concerned property, and if so, to what extent. Stop. Paragraph, such report is filed in court today. Stop. Let the same be kept with the record. Stop. Copies of such report have been made available to learned advocates for the other parties. Paragraph, accommodation is sought for on behalf of the appellant. Stop. Let the matter stand adjourned for the day.
Grateful.
Grateful.
Much obliged, my lord. Dada.
Lord, for the appellant in this.
Yes.
My lord, though it has been served, state learned advocate for the state appeared on the last occasion. It is regarding the challenge to the Pradhan's action. My lord, the Pradhan has already been served, but the difficulty is, my lord, it is not stitched with the affidavit of service because it has been subsequently the delivery report was obtained. So, my lord, not being able to appraise your lordship with this affidavit of service presently.
How is this before us? Retention of land for tea cultivation.
It is what happened exactly. The land is a tea garden. Now the Panchayat authority is calling for Shalishi Shavas. Though it is pending before the concerned LRTT, the tribunal, the Panchayat authority overstepping its jurisdiction as calling for Shalishi Shava, that you come and settle with the private respondents. Those who have already encroached into that tea garden and they are plucking the tea leaves. Now we challenge the action of the Pradhan. That Pradhan has no jurisdiction and authority to call for Shalishi Shava and settle the issue because the concerned Panchayat has interest in the tea garden. That is what was challenged before the Honorable Single Bench. Now, possibly, my lord, it has in a different way, it was reflected.
Anyway, you complete service and come back.
Yes, my lord. On the next week, my lord.
Learned advocate for the appellant says that service is not complete. Appellants করে দাও. Not complete, paragraph. As requested, comma, let this matter stand adjourned and be listed again on next Wednesday করে দাও. Stop. On that date, affidavit of service will be filed in court.
One leg. Mr. Gunjan Shah.
কিছুই শুনতে পাচ্ছি না.
Mr. Gunjan Shah.
Not today.
Your Lordship, then kindly make it, make not this week.
Not this week. পনেরোর appeal, উড়িয়ে দাও, উড়িয়ে দাও. Same. 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 Stop, পনেরো. Give your name, give your appearance. 14টা কি হয়েছে? Time হয়েছে. ইচ্ছে করে করেছি আমরা 15 appeal.
I am paying for some one, not this week.
It's your appeal.
No, I am not, Madam. Mrs. Shima Chakraborty is the advocate of the court and he is not come to court today due to his illness.
Not this week.
Not this week.
My lord, item 20, I am for the appellant.
Yes.
I have been instructed by my client, she doesn't want to continue the proceedings.
Right.
Kindly dispose it.
Sure.
Give online order that it. Give online order.
Yes, yes, certainly. Lekub, learned advocate for the appellants, says that he has instructions not to proceed with this appeal. Paragraph, accordingly, comma, the appeal is dismissed for non-prosecution. Stop, interim order, comma, if any, comma, stands vacated.
Much obliged.
Your Lordship, may I permit it to
No, madam.
item number 15, Lord, I was running from other court, Your Lordship.
Which matter?
Item number 15, Your Lordship.
15. What is there? 2015 appeal?
Yes, Your Lordship, the brief has been misplaced, Your Lordship.
Then how can you do the matter?
Lordship, kindly adjourn for this matter for a fortnight, Your Lordship. We will try to find it out, Your Lordship.
Very well. On the prayer made on behalf, 15 number. On the prayer made on behalf of the appellant, comma, who, on the request of learned advocate for the appellant, comma, who says that she has misplaced her brief, comma, we adjourn this matter for a fortnight, comma, to be listed again on date ta diye dao.
Grateful, Lordship.
Item number 21.
DD karo.
My lord, I am for the private restaurant.
Give your appearance. ছিল না তো?
26. 27. 28.
Oh,
Item number 29.
okay. Yes, 29 to parted matter. First call করে দাও একটা।
Item number 30. 34. 35. 36. 37.
My lord, I am for the respondents 1 to 11. Advocate Suhid Mitra was arguing in this matter on the last occasion. If you lord. No, no. If you also kindly pass it over for Sam, I'll just.
Eight. 41. 42. 43. 45. 46.
47, my lord, I appear for the petitioner, my lord. My lord, kindly make it, Mr. Orindam Mondol, my lord, appearing for the alleged contemner. He has appeared on the last occasion. My lord, kindly make it not noted. It's not possible, I think. 47. Shahjahan. Not it.
48.
49, my lord, in this matter, Mrs. Pampada Devaji appearing, my lord, kindly make it not today. My. 49. You kindly make it not this. Yes.
51. 52.
Kindly for not today. 38 to 40. 38 to 40. Hello, kindly for not today.
53. 54. 5. 57. 58. 59. 61. 62. 64. 65. 7. 8.
My lord, I'm appealing for the.
9. 70. 71. 72. 24. 75. 76. 77. 28. 29. 80. 81. 82. Single item number 29. Second. Number 30,
Same matter, Baba.
34. Kolkata Municipal Corporation, led by all of them. Paying for not.
Not today.
If 38.
Lordship, I for the respondent.
Lordship, kindly bring on not today on
38.
38 and 40, my lord.
We are prepared to hear you,
But only 10 minutes left.
not even that.
But the only thing, Lord, most of the hearing has been concluded. Some documents I have to refer and some few judgments only. If your lordship kindly takes it up tomorrow. Of course, I am enjoying an interim order passed by your lordships.
এইগুলো
38,
থাকবে না?
40.
31
39 is by the respondent's appeal.
29, 30, 31, 32, 33 তো থাকছে না। 29, 30 এর পরেই দিন। Mr. Ghosh,
My lord,
tomorrow it will be listed
my lord.
as the third hearing matter. The first two are connected matters
Yes.
as the third hearing matter.
Third hearing, subject to your lordship's convenience, time will permit.
Yes.
But I am here every day.
I have noticed that. My brother has also noticed that. বুঝতে পেরেছো তো? Third hearing matter থাকবে।
41, I'm for the petitioner, my lord. This could contain matter. Time length.
My contempt would be tomorrow you will also can be heard the matter.
Mr. Bachai, we have to rise.
No,
There is a different bench.
Yes, yes.
Because your lordship remember.
Tomorrow,
Direct,
tomorrow,
your lordship heard
It
the
will be,
matter.
it will run in the list, same.
কালকে থাকবে।
Children. 42,
No, Lordship, I beg to
42 dismiss, 11
I beg to mention on matter, Lordship. Item number 21, Lordship. It has been made dismissed for default, your Lordship. I was there engaged in courtroom number 8, your Lordship.
What is the matter about?
Lordship, we are for the appellant, your Lordship. The appellant has expired, and right now at this moment, the legal heirs of the appellant, they could not be contacted with. So we need some time to contact with so that we can file a substitution.
2018 appeal, you've taken no steps, madam. When did he expire?
Lordship, I'm not.
No, nothing.
Mr. Lahiri is appearing, Lordship. He is engaged.
Adjourned for a week. 20, it a dismiss of.
21st, 21.
21 to adjourned for a week.
Grateful, extremely grateful.
42. You are appearing in 42 for the petitioner. Yes, tell us. Which one?
Number 42. 42, my lord, we have already served the compliance report, my lord. So I will serve in course of just bring my brief. In that compliance report, we have specifically mentioned that order of Justice Sengupta has been complied with. Now, in turn thereof, the Baranagar mission has told us that we will not take him. So if they said, my lord, that they will not provide him, so what can we do? It has been specifically mentioned therein, my lord, in the reply which they have given through email. And that I have annexed in my report.
You have filed in court.
Yes, my lord,
I am for the applicant.
I will file in just now by bring. It is in my
Then Mr. Basuli will make it not today because we are rising now.
Oh, his file is reply because I will.
Not accept, my lord, because he was unwell and therefore
Your lordship.
Then Mr. Basu you
I just now, may I file?
but dismiss করো না লেখো affidavit of compliance filed in court today be kept with the records. Records, the affidavit of the petitioner in response to the affidavit of compliance, comma, filed in court today be also kept with the records. Paragraph. Today, there is no time to take up this matter for hearing. Stop. Let the matter be listed once again tomorrow. Tomorrow? কালকে ডেটটা দিয়ে দাও নিয়েছো তুমি affidavit of compliance সব দিয়েছে come back tomorrow.
Item number 35 below, your lordship will please to dismiss the matter.
35 কি করেছি nothing has happened.
Nothing.
Good. Only for filing written notes. For the appellant.
For the employee.
Oh, for the employee. ठीक है ना? Written notes of argument filed on behalf of the respondent oblique writ petition. Comma be kept with the records. You have already filed yours. Paragraph hearing is concluded. Stop judgment is reserved.
Number 4. My lord, in this matter, I am for the appellant, my lord. On last occasion, your lordship's pleasure was to direct that against the judgment and order passed in WPA number 15519. I should obtain a stay order and then your lordship will hear the appeal, my lord. And I have filed the appeal. I have filed a stay application. Stay application was due to be listed today before the division bench presided over by the Honorable Chief Justice. Today it has not been listed. That is the position.
You want adjournment?
My lord, your lordship said
Even
your
se koi
lordship will
bujhbe
hear it.
Achhe.
Your lordship's order of 2nd August. Your lordship said like this in that order. However, we are still of the view that we should await the result in the stay application that the appellant proposes to file in proposed appeal against the order of the learned single judge passed on in WPA number 15519 of 2022. That was your lordship's observation. And my lord, it is expected that the my lord, it is expected that
Your matter has not been dismissed. Very well. We will list this matter again when we sit together.
It is expected that stay application will
Very well.
next week, my lord.
Mr. Ghosh, we'll let it, we'll just say not today.
I am obliged.
Not today. Now, file now.
This matter was heard by lordship earlier.
You are for the bank. Cooperative bank.
Last action. Submitted that before that.
But your lordship have photographic memory. Your lordship remember everything. Still, in my humble way, I will point out certain basic points so that I can complete my submissions. My lord, a current account I used to maintain with Birbhum Central Cooperative Bank, which is now under the scanner of CBI. This particular bank is now under the scanner of CBI. The current loan account was for rupees 45 lakhs. A dispute case and a requisition has been filed under section 128 of the West Bengal Cooperative Societies Act 83, earlier act, to the Assistant Registrar of Cooperative Societies for recovery of 4 crores and odd. The Assistant Registrar of Cooperative Societies passed the award for 4 lakhs odd plus 1 crore sum for interest and 12% interest till recovery. And also with a direction that within a particular time, if I have not paid the money, they will recover the money from me by Public Demerits Recovery Act, which was not called for under section 128. The decision-making authority passed the order of execution. Then it has to be executed. I came to this honorable court, challenging the award because at that point of time, tribunal was not sitting.
Now tribunal is there.
I do not know. mostly not sitting, subject to correction. Sitting, I do not know. একটা?
শুধু একটা বেঞ্চ ট্রাইব্যুনালে একটা বেঞ্চ অ্যাভেলেবল।
ট্রাইব্যুনালে 3 জন লোক দরকার। I don't know, মানে tribunal consists of 3 members having 1 chairman in view of the decision of our High Court. I do not know what he is saying. I don't know. This honorable court heard the matter and held that the order was passed without any reason. But my lawyer, Mr. Ashish Hon'ble, made a submission that my client will pay 2 crores and so that the execution proceeding may be stalled. And it was also directed in default of payment, execution proceeding will proceed. I paid only 10 lakhs. I could not pay.
Court accepted that suggestion. Court accepted that suggestion.
অ্যাকসেপ্ট করেছিল।
Court accepted and recorded the order. Paid, I only paid only 10 lakhs. Bank, very interesting point. Bank was then represented by Mr. Dhiman Gupta. State was represented by Mr. Keshav Bhattacharya. Bank subsequently, in spite of default clause, that if I do not pay but cannot pay, bank will proceed with the execution proceeding. In spite of this particular direction, bank filed an application for contempt. Curiously, that contempt application was accepted by the Honorable Court and accepted my payment of rupees 10 lakhs and resolved the matter. No order is passed in the contempt proceeding. At this juncture, my first submission before your lordship. The trial court passed an order that the award cannot be sustained in law because no reason has been given. Thereafter, on the basis of an undertaking of my lawyer, at that point in time, my client was not present anyhow. This court passed an order that if that particular 2 crores is paid, execution proceeding will be stayed. In default, will proceed. Whether that can gives a power or authority upon the bank to file contempt in spite of default clause. Mr. Bachawat appeared on behalf of the bank. Mr. Keshav Bhattacharya appeared for the bank. Who is appearing for the state? My whole case, which I built up, is a conspiracy between the bank and the ARCS to kill me by passing an award of 4 crores plus 1 crore and odd and plus interest in respect of an amount payable of 83 lakhs.
Where is the impugned order, Mr. Bhattacharya?
Now I am come to you, lordship. Kindly see, my lord, and also I will show the discrepancy between the original record and the certified copy. Kindly comes to my lord page 67. conspiracy is very much open. My lord, kindly see page 67. I'll show the conspiracy now. This is the notice. My lord, kindly see bottom, 67 bottom.
Yes.
Examine the secretary and the records and the account and heard the defaulting members and took evidence. I am satisfied that amount of rupees such and such, principal amounts plus such and such. The defaulting member also admit his debts. This particular certified copy.
No, this rupees is blank. What is the thing? Blank.
Some places blank, but subsequent these particular places is also blank from the original record. I will show my lordship the original record, which is totally blank. Can you see, my lord? এখানে দেখাচ্ছি আরো। মামলা করবে না তুমি কি মামলা করবে ভাই? তোমরা যে কি আরম্ভ করেছো না please, I will proceed on me my own. I know what is what. Please, I know because he is very interested in the particular matter. I will not comment at the present moment.
5 crore 66 lakh.
My lord, kindly see.
5 crore 66
My
lakh.
lord, kindly see page 67. My lord, got it. Now, my lord, I am showing you lordship original record I obtained by RTI. Kindly see. What is in the certified copy? What is in the original record? Handwritten order. Kindly see. তোমার গভর্নমেন্ট থেকে নাও, তোমাকে দিচ্ছি আমি, কিন্তু গভর্নমেন্ট থেকে নাও। গভর্নমেন্ট তো লয়ার বসে আছে, তো অনেক টাকা পয়সা নিয়ে বসে আছে। ধরো তোমার গভর্নমেন্টের লয়ার অনেক টাকা নিয়ে বসে আছে, My lord, kindly see original serious discrepancy between the original and the certified copy. Kindly see, my lord, this particular portion herein such and such 5 lakhs and 1 lakh, 1 crore, 1 such and such, 1 crore defaulting member, and now is a defaulting member and the secretary of the same to appear before me with necessary evidence, records, and books and accounts. Kindly see the right hand side, his signature. Because Bhattacharjee is the assistant registrar, has the book, both the parties to make over the records, and this is. But now in the certified copy, you also can see the blank portion has been written. Defaulting member admit the dates, which is blank here. Certified copy before the Supreme Court also we suffered. My learner, my client suffered. This is the original certified original copy.
So we have not been able to follow what the discrepancy is.
My lord, kindly see this is the original order sheet.
Yes.
Kindly see, it is written up to BDCC Bank branch to appear before me with necessary evidence, records and books and account, signature, assistant registrar of cooperative societies. My lord, got it? Right hand side, handwritten portion.
Yes.
Up to this, the assistant registrar signed the order. But in this case, In the certified copy, it has been written. Kindly see, my lord. Examine the secretary and the records and the account, and heard also the defaulting members and took the evidence. This is not there. This is blank here because this is first day. But in the certified copy, it has gone down, for which this particular code has been misread from the very beginning. Initiation has been taken to be the final. My lord, I have
No, this is, they examine the secretary and records and the account and heard also the defaulting member and took evidence.
and in the original, you will also kindly see.
In the original, it is there also.
In the original,
It is there.
kindly see. PDCC, kindly see. Assistant Registrar, my lord, has seen. Cost from the above mentioned defaulting member or the defendant member
Eight of the,
or from certified copy I am showing secretary of the BDCC bank branch to appear before me.
I have tick marked.
This particular portion, this particular portion the cause of action of the particular portion did not arise at that point of time. This is only for appearance date. This is for appearance. You can see to appear before me with necessary evidence, record, books and accounts. And this was the printed document. This was not done. Examined, such is not done. Kindly see his letter. Here, both the parties, branch manager, PDCC bank, asked to make over the detailed transaction to the defaulting member, the handwritten portion. Handwritten portion. At the time of typing, the certified copy, mistake was done, which was not to be recorded.
We'll come to this, Mr. Banerjee. Kindly show us the impugned order once.
Yes, I'm showing you. No, impugn order. Kindly comes to impugn order at page. Page 72. I quote, no, I'm showing you lordship award. High Court. High Court. 230. High Court. Only comes to tomorrow.
85.
85. Only comes to 85. My lord,
The problem is, Mr. Banerjee, this order says it is an agreed order. Agreement of parties, the following order is passed.
My lord, agreed order will not survive.
Will not survive if you fail to pay the amount. It also says that. So therefore, this order is gone.
That means this order.
This order has lost its force.
Lost its force.
So therefore, nothing remains of the appeal. Your appeal is allowed.
Kindly first portion,
Which portion,
kindly see.
The operative,
Page 85. It appears to this court.
the entire,
Bottom.
we will clarify that the entire order has lost its force. Nobody will be able to rely on this order.
But
And this finding that it appears to this court, this is also not supported by any reason. Sir, we cannot keep this order. In any event, the order itself says that the order will lose its force if payment is not made by Mr. Vishwas. Mr. Vishwas did not pay or could not pay, whatever the case may be. So as per terms of the order itself, this order ceases to exist. This order was subsequently? This order?
Against this order, because the bank is going.
Reach on your microphone.
My lord, when the bank is on the condition that if they fail to pay this very particular amount, then my lord, when we proceed for the sale, then this order was going before the Supreme Court, subject to, and it was, that application was, it has been not pressed before the Supreme Court.
No, we have gone to Supreme Court for other
But against this order,
different orders, not this order. We have not gone. They went before the court for contempt.
Sir, whether they have gone before Supreme Court or not is not relevant for us today. Today, an appeal has been preferred against an order of a learned single judge. The order records it is an agreed order. It's a consent order. That is what it records.
Nobody can decide from it. Nobody can decide it.
Nobody can decide what.
No, nobody can decide.
He has not read the consent order.
Correct.
At that time.
But the order itself provides that if the petitioner fails to deposit the aforementioned amount, which means 2 crore, within the period indicated above, this order will be deemed to have lost its force. So there was a default in payment. So this order has lost its force. What remains? Why fight on this? Proceed against him in accordance
We
with
are
law.
already proceeded, my lord. We have already sold every property.
Then we are not saying, we are just saying.
My lord, we have become only able to get 1 crore from the present petitioner. Because some, my lord, subject to kind sanction, my lord.
We are not concerned.
My lord,
We are not standing in your way of recovering till your last penny.
My lord, this appeal was preferred by the present petitioners, my lord.
We are
So-
disposing of the appeal. That's what we are
And my
saying.
lord, is what we are only saying that, my lord, that we have only able to get 1 crore from the present petitioners or appellant is concerned, my lord. So for the rest are concerned, my lord, we have also alleged before this paper book, lordship will find that during this pendency, they have tried to sell, tried to transfer, tried to change the title of that very particular asset.
Why are you telling us this? You expect any order from us?
No, my lord.
Then why? We'll
Appeal
just
is
dispose of the
considered
appeal.
my lord. So for appeal is gone, there is no.
Yes. We'll clarify that in terms of the order itself, the order has lost its force. Any observation in the order will have no further effect.
My lord, so far the award is concerned, my humble submission, your lordship kindly direct these read petition to be heard again.
Yes, my
On
lord. That
merit.
was the problem, my lord.
To be
That
heard
was
again
the
on merit.
problem.
My read petition should be heard.
They want to lost his first award also, my lord, subject to gain sanction.
Then I will
That's why
suffer.
we're standing.
No,
If
Mr.
the
Bhatt.
award remains, I will suffer.
Agreed order,
Then
agreed
how
order.
can I
Has,
come before this honorable court, challenge the order? This is the difficulty.
My lord.
no.
Then he will also kindly set aside the award. I am throwing the award. Either award can be sustained. Kindly see the award. Page
The
72.
the award has already been executed.
Executed, my lord.
Page 72, my lord, kindly see the award.
And we have faced so many problems during execution of this.
Kindly,
The award was under challenge in the writ petition.
award was challenging the writ petition.
Where is the prayers of the writ petition? Yes.
Yes, my lord, page. Yes, page 220, page
118.
25, kindly see.
Page 118.
Page 25, kindly see, page 26, volume number 1, page 26. Imperial order dated 10th February 2009. Page 26. I have made the prayer. এটা ডিস্টার্ব করে কেন আরেকটা পৃষ্ঠা দেখাচ্ছে আমি দেখেছি একটা খুঁজছি কি যে আরম্ভ করেছো না তোমরা আর ভালো লাগে না আর আসবো না আর আমি
Sir, come to page 72. This is the award.
My lord.
Page 72.
in the award no reason has been given. I'll show authorities before you lord.
This you call an award.
No reason has been given.
72, 73.
72, 73.
Page 72.
No, my lord, there are some proceedings, my lord. That was not the part of the documents, my lord. The proceeding which has been called. That is
Where is the award?
My lord, we have also produced. the
Come
award,
back.
my lord.
Next day, this will be the first hearing matter.
Lordship,
This will be the first
and
hearing.
lordship is pleased to ask the award regarding only the award as because it is not the reason order.
Yes.
My lord, I shall satisfy. I shall satisfy your lordship. And my lord,
Was that it is a reason
I am
award?
also praying one more submission, my lord, that the procedure which was followed regarding passing this particular award and this record will be before the state authority, my lord. That may also be produced before your lordship because that is not
Mr.
the
Roy, produce the records. Produce the record issue.
lordship.
Heard Mr. Bhattacharya, learned senior advocate appearing for the appellant, at length. Stop. He does not conclude his argument. Paragraph. List the matter. Ay, কবে ঠিক হলো যেন? 5 হতো। কবে কোটা original side এসছে কেউ? এসছে?
Yes. Birbhum, sure.
Oh.
Is a party for us.
This will be either 5th September or 14th September. We can't tell you now. এটা এভাবে লেখো. Let this matter be listed again when this bench assembles. We will display the matter 2 days before in the list so that you get adequate notice. Paragraph. On the next date, the state is directed to produce the records of
The
the
dispute case.
proceedings culminating in the award dated February
10 February 2009.
2009 in connection with the proceedings under section 128
128.
of the West Bengal Cooperative Societies Act 1983. Mr. Roy, you proceed on the basis that this matter may be listed on the 5th of September and accordingly ask your client to make available.
ARCS Birbhum, COD.
Huh?
State respondents will not be concerned.
Assistant Cooperative Registered Society, Birbhum.
Cooperative societies.
ARCS Birbhum, my.
So that it should be there.
কি বললাম না অন দ্য নেক্সট ডেট কি বলেছি
Respondent number 3.
না স্টেট করো না তাহলে অন দ্য নেক্সট ডেট দি রেসপন্ডেন্ট নাম্বার 3 বিইং দি অ্যাসিস্ট্যান্ট রেজিস্ট্রার অফ কোঅপারেটিভ সোসাইটিজ comma Birbhum is directed to
My lord, before your lordship rises, my lord, may I have your lordship's kind indulgence to file written notes of argument on behalf of state respondents? Lordship, kindly, my lord, allow me to file. My lord, in item number 1, 2, and 3. I am for the state respondents, my lord. This only may be kept on record, my lord, on behalf of state respondents.
এর জন্য নেওয়া হয়েছে অ্যাপেলেন্টের খালি বলা আছে কেউ তুই ছিলে না কেউ অন্য কেউ ছিল রিটেন নোটস অফ আর্গুমেন্ট লেখো না এক নম্বর আইটেমটা 1, 2, 3 একসঙ্গে হবে রিটেন নোটস অফ আর্গুমেন্টস ফাইলড অন বিহাফ অফ দি অ্যাপেলেন্ট অ্যাজ ওয়েল অ্যাজ দি স্টেট রেসপন্ডেন্ট করে দাও কে নিয়েছে দেখো কে বলে করে দাও